Madam Chairman, we're live now.
Thank you, Ms. Vaughn. Welcome back from lunch. We'll pick up where we left off. We'll start with parimutuel wagering, historic horse racing and local control policy areas and draft legislation. The policy, let's see. LSO.
Madam Chairman and members of the committee, this agenda topic relates to what we've been talking about all day, which really is the subject of today, is historic horse racing or simulcasting. And the committee requested to look at what was House Bill 185 during the 2025 session. It's now been sort of brought back to you, and it appears to you as 26 LSO 0145. And as we were planning this agenda and talking through with the chairs what to list on the agenda, some of the items that I think that you wanted to remind the committee of, to be conscious of as we go through the draft legislation, is all of those items listed on your agenda, those policy areas such as local control, the city role, the county role, the role of the commission, numerical limits, options of a moratorium, transferability of license, the voter's role, and this, how to deal with existing operators, whether you grandfather or phase in or phase out. And all of those items are areas of policy decisions that some are within this bill draft, some did not make it in this version, but they could be areas of policy that you legislate on, or that you ask, well, what is the status quo on? Do we need to legislate on? So I can jump in and explain 26 LSO 145 if you'd like to start there.
Yes, please proceed.
Okay. So that's working draft 0.4, and it was modeled on the engrossed House Bill 185. That bill had come from the Joint Appropriations Committee, which had come from the Gaming Working Group. It went to the Travel Committee in the House. The Travel Committee had some amendments that were made after 2 days of testimony during the session. That passed the House, and then it went over engrossed, and that's the version we're working from here. Mostly, I did go through and make some technical corrections, or have other attorneys look through it too and see some improvements in the language. Then I also made changes based on LSO's pre-meeting with the co-chairs. So those are where those changes have come from. This is listed as sponsored by Senator Kolb, and he has to take credit for it because this is a committee that can't sponsor its own legislation. And so for our system, we need to use the legislator's name, and we use the chairman's. This act, just jumping into now the title, it generally relates to parimutuel wagering, specifies requirements for permitting simulcasting. This includes historic horse racing terminals. It requires approval by a city, town, or county for the issuance of a simulcasting as specified, authorizes conditions and revocation of approval, authorizes appeals, amends enforcement requirements, conforms provisions, and specifies applicability. Section 1 is all new language. We're within Title 11, Chapter 25, a new Section 210 at the end of all the horse racing statutes would be created in this Section 1. So on to page 2, new language, generally kind of recreating some of the language that will be repealed from definitions. So if you think about it right now, most of the simulcasting governance is within the definitions section for the parimutuel wagering chapter. So we repeal those out at the end of definitions and then recreate part of it here. And I'll try to be clear which parts we're keeping and which parts we're losing. Subsection A states that simulcasting can only be conducted by someone who has a permit that's issued by the commission. That's the status quo, that's existing law, and approved by the local approving authority under this section. That's new. Currently, it's conducting parimutuel wagering off of the permitted premises needs to be approved by the county. This is saying needs to be approved by the local approving authority, which could be a city or a town, as we jump into the next couple subsections. Subsection B is existing language. This is what the legislature has given to the Wyoming Gaming Commission as their guidance for what they should put rules out for administrative rules. And it says they shall promulgate rules for simulcasting that are reasonably necessary to protect the public interest. So a broad grant of authority for rules there. Subsection C, and again, that was existing law. Subsection C is to clarify that a simulcasting permit is a type of parimutuel permit, and except as specifically provided in this section, it would be subject to the same term, same conditions, issued and renewed in the same manner by the commission as their live parimutuel event permits. And subsection D further specifies the existing requirements for simulcasting permits, but now brings in cities or towns, where existing law only allows counties to approve. This would bring in cities or towns. And this page 3, lines 1 through 15, lines 1 through 10. This is a policy change from House Bill 185 that you saw. This says if the simulcasting is going to be conducted in a city or town, the permit or renewal would be subject to the approval of that city or town, their governing body. If it's conducted outside the corporate limits, it would be subject to the approval of the Board of County Commissioners of the county. So fairly large change there. What had happened in 185 is that there was sort of a shared approach where the entity that is not approving it, the county, if it's in the municipality, or the municipality, if it's out in the county, would still have some ability to comment and grant some review and ask that any issues they have be remedied before the entity that is granted the approval goes ahead and gives it a go-ahead. So sort of a multi-layered process. This just puts it black and white. City approves city, county approves counties. Then subsection or paragraph 3 on lines 12 through 13 is existing language. And that reiterates that a simulcasting permit or renewal shall be issued by the commission only to an applicant authorized under this act to conduct a parimutuel event other than simulcasting. Now, if you were going to bring back the 100-mile rule, because House Bill 185 repealed that and didn't recreate it, this is probably the logical place of where you could put it, because this is where it sort of sits in relation to the other statutes under existing law. So it would probably be on the bottom of page 3 in this form. You know, you could put it in a lot of places, but you could put it on the bottom of page 3. And if you wanted to put it in exactly like it reads in existing law, you would just use that language on lines 24 through 30 that no simulcasting may be conducted within 100 miles of any premises permitted under this act, except that the commission may waive the 100-mile limitation if the simulcasting permit application includes written approval from the permittee whose permitted premises is within the 100-mile limitation. That's what it would look like if you just wanted to readopt what is there. If you wanted to adopt the 100-mile rule, but perhaps clarify the language a bit or clean up the language a bit so that it wouldn't need Attorney General approval or opinion to understand what it meant, you might write it something like is portrayed on page 4, lines 12 through 19, to just clarify that it would be the 100-mile rule would apply within 100 miles of any live parimutuel event during the time the event is being held. So that's a policy decision and wasn't included in the text of the bill. We need a motion or direction to put it back in. Then moving on page 4, subsection E relates to the rights and duties of the applicant, directs that an applicant for a simulcasting permit or a renewal shall file an application with the local approving authority. And that's a city if it's in the city or town. It's county if it's in the unincorporated areas. Renewals would be due 90 days prior to the expiration. They'd need to pay an amount sufficient to reimburse the costs of publishing notice. They'd need to identify in the application The specific location in the city, town, or county where simulcasting will be conducted and the number of historic horse racing terminals to be permitted at that location. This is a technical change where I took this language from another part of the bill because I thought it worked a little better here, but was not intending to have any other effects. What it's saying is that when you apply, you need to let that local government know what you're applying for, how many terminals are you looking for, and what do you expect your business to look like. Subsection F on page 5 relates to local government procedures, and there's some due process rights in here. After an approval or renewal application, the local approving authority need to prepare and publish notice. Need to put that in the newspaper of local circulation for 2 weeks, once a week. Post the notice on its website and state that protests against the issuance or renewal would be heard as a designated meeting of the local approving authority and when that meeting will take place and where. For renewal application, the local approving authority would need to hold the designated meeting not later than 30 days prior to the expiration of the permit.
May we kindly interrupt? Senator
Absolutely.
McEwen.
Thank you, Madam Chairman. I'm just curious, we were talking at lunch today. Let's say we're doing this in Evanston. There's no newspaper. So what's the answer for that?
Madam Chair and Senator, that's a great question. That's certainly something that's coming up with many notices that are in Wyoming statutes that newspapers model has changed. It says a newspaper of local circulation once a week. It's probably a bigger issue than for this bill, but you can draft it otherwise. Otherwise, I think that the localities are interpreting it to be whatever is being circulated generally, closest that they have.
Follow up?
So we should put it in Auto Trader? Thank you.
Senator Cole.
Thank you, Madam Chairman. We probably need to leave this more broadly than it's stated, because you're right, currently our statutes are written in this way, but of course we're facing a new reality here, which we frankly tried to head off years ago, but we're resisted by the newspapers of doing it in some other methodology. So the time has probably come, but let's just keep it open. And obviously we have to mimic current statutes. We're, going to run off, and has to be a one bill subject. So talking about language on publications of public record is subject unto itself. But yeah, just keep it kind of a placeholder open there, I think would be our best bet right now, because yeah, we are challenged now with not having a newspaper, quote unquote, a record.
Thank you, Mr. Chairman, Madam Chairman. Yes,
Thank
and I'm aware that we've changed the language. This was taken, I believe, directly from the liquor licensing laws, but more recent legislation has addressed that reality. And I can prepare that language for an amendment if you'd like to go anywhere with this bill or with the concept of notice. I'll continue with the bill explanation if there's no other questions on that. The bottom of page 5, lines 20 through 23, highlighted there in yellow, if you have a color copy, was an amendment that came in from the travel committee and allowed a permit holder in advance of that designated meeting to request a contested case hearing. One of my technical corrections was to clarify this was in accordance with the Wyoming Administrative Procedure Act. However, in working this in, I think I will need some direction for the committee on what sort of the intent of that was, because the Administrative Procedure Act and contested case hearings are common with agencies and with counties, but by definition, cities and towns aren't considered an agency for the Administrative Procedures Act, which is the statute that dictates the rights and all the processes with a contested case hearing. So I believe cities and towns often have their own form of a contested case, but we might just need to flesh that out, what kind of, rights they're intending to afford with that amendment. On page 6.
Could we interrupt one more time?
Sure.
Co-Chair Cole.
Thank you, Chairman. Just a general broad question about that amendment that the good folks at TRW stuck in there. I would need to hear your opinion, or if you don't think about it, about the need for this. I mean, do we have to have it in there or not? If it's, not helpful, then, I would say we talk about pulling it because it's not getting us anywhere, but you need to rely on the LSO and their expertise on what your opinion is on this, and we'll keep it here for now, but need to figure out if it's germane or not, or if it's causing us more grief than help.
I can comment that I initially wondered, well, at that point, there hasn't been a decision. There's no determination to sort of contest at that point. However, when we get to the end of the bill, you'll see that other rights, which are based on liquor license laws, are only afforded to existing permit holders. So a brand new applicant in this bill draft, and we'll get to it, would not have a right of judicial appeal under the bill itself. They'd have some other general judicial access to the courts, of course, ability, but no specific right under this law to be able to have their decision looked at that they may have feel was done arbitrarily or capricious or otherwise. So this is really the only place that exists for this bill for a new applicant to be heard, is in this asking for a contested case before the city or town or county has even made a decision.
Follow up?
Well, continued follow-up. Thank you, Madam Chair. Are we causing us, I mean, I get it. They have no right at this point. So then we're giving them a right within this language, which may turn around and be more problematic for us than just leaving it out. They want to argue this in court, they can. But for us to put it in there would seem like we're granting them some legislative right for something they don't have a right for currently, which I think is what, if I remember right, the conversation was during the Senate kind of conversation about this bill and how it came out and why it didn't go anywhere. I mean, it's one of those things, but so once again, I think need to explain to the committee at some point when we talk about this, that why it's good or why it's bad to send here, and do we need it in there? I think that's, now that my memory got jogged. So that's important, I think, for the committee to know and to make a decision that's informed.
And in the audience, we may have members that attend other committees that may be able to offer more insight having attended those committees, and we would welcome your feedback during public comment on this legislation. Please continue.
Right, I'll move on to subsection G on page 6. It starts on line 19. This section relates to the local government's duties, rights, and limitations. So this is the section that's really new. That's, right now, statute says county shall approve in order for a parimutuel event to be conducted off the permitted premises. This now provides some guidance on not just approval, but what other rights and duties does that local approving authority have, and what are they limited to? And it morphed through the drafting and amending process of House Bill 185. I think in the very beginning, when it was brought to the Joint Appropriations Committee, it more closely resembled the liquor license kind of standards, but this is where the bill ended up after all of the work that was put into it. So paragraph 1 says the local approving authority shall not approve or deny an application before the date set for the designated meeting. 2, shall not consider, modify, or impose conditions that are solely within the jurisdiction of the commission. Because again, a lot of this bill draft and the existing statutes leave most of the meat to the commission of background checking applicants, of looking at all of their paperwork and really setting the standards and then being on the grounds with them. That's still all within the commission's authority, and this bill draft doesn't change that. It just changes that approval aspect. 3 on page 7 is may impose reasonable conditions on approval, which shall be negotiated in good faith with the applicant, including the following. A is a schedule of operating hours that's at least not more restrictive than the hours of operations for alcohol sales. B is designation of areas within the premises where the terminals can actually be located to the extent not inconsistent with the commission's rules. 4 on lines 16 through 18 is allowance to modify any condition imposed under paragraph 3 only upon a showing of good cause. So there's that standard that is somewhat ingrained in this bill draft is good cause and good faith. 7, paragraph 5, on page 7, paragraph 5 is shall grant approval for the same term as is granted by the commission for the simulcasting permit if it's approved. So the timelines will match up for an applicant and what they get from the city or town or county and what they get from the commission. So they're on the same cycle. Their permits and approval are running together for the term. On page 8, paragraph 6 is shall issue written findings and conclusions if the application is denied. Got to put that in writing of what, what their causes are, why they're making this determination. 7 is shall have the right to revoke approval or deny a renewal only for good cause, which shall be limited to the following. And so these would be the only reasons that city, town, or county could revoke their approval. A is there's a breach in the conditions that were imposed and the permit holder fails to take reasonable steps to cure that breach within 10 business days or another day if agreed upon. Subparagraph B is notification from the commission that the permit holder has acted in violation of Wyoming gaming law as specified in this chapter, or the criminal statutes or the other provisions on the Wyoming Gaming Commission. Subparagraph 3C is failure to demonstrate commencement of actually simulcasting at the permitted premises within 2 years, except that it may be extended by 1 year upon a showing of good cause. In my staff comment there on page 9, I provided the existing statutes for liquor licenses in Wyoming Statute 12.4.104B. They look pretty different at this point. These are when a local licensing authority, a city, town, or county, can deny a liquor license. And those are articulated there in that staff comment if you want to compare it. On page 10, H addresses the judicial appeal. It allows a simulcasting permit holder to appeal a denial or renewal or revocation of approval by the local entity to the district court, and says that during the pendency of the appeal, the approval of the local approving authority for the person to conduct simulcasting shall remain in full force and effect. So again, this is H is a right that's offered to existing permit holders only. And J just clarifies that that right does not extend to new applicants for simulcasting permits. It is modeled on Wyoming Statute 12.4.104E, which comes from your liquor license statutes, and that staff comment on page 10 just shows you how it's worded in the other instance in statute. Subsection K came in as a TRW amendment within the House during session. And it says that subject to the local authority approval of a transfer of location, the transfer of an existing simulcasting permit shall be treated as a renewal of approval for a simulcasting permit. So I thought I might try to work with the committee on this bill if this goes forward to better understand the intent and how transfers are envisioned or desired to work under this statute and under existing statutes. Simply because existing statutes, and we'll come up to it in just a little bit, do sort of direct that no permit be granted to an entity except upon this express condition that it won't lease, contract, or grant or sign or turn over their rights. But I think things are not as black and white as it's in the statute, because sometimes an entity stays the same. An entity, an LLC, or other corporate person receives a permit, and that corporate person can go and renew it. They can change ownership, can change members, so they can reapply to the Gaming Commission to have their HHR terminals at a different location if they're permitted at a different location. So it's kind of intertwined, and I would want to work out some of the intent to understand if the subsection K is written as desired. But right now it just says that subject to the local authority's approval, the transfer would be treated as a renewal, meaning it could only be denied upon good cause. So subsection 2 is the conforming amendments and other amendments to existing law. these are the beginning of this chapter that we just created a new section 110 in. We go back to 102 existing law and amend it. On page 12, the beginning of the definition of simulcasting is stricken. And that's because all of the regulations that are within the definition section for simulcasting would be repealed later in section 3. So right now this exists in the definition. We're cleaning it up out of the definitions, striking that intro and recreating it in the new section. Then adding to definition section.
May we interrupt? Co-Chair Cole.
Permit, and you transfer the 3-year permit in between that 3-year period you have the permit issued, the same 3 years will apply as it started off to run that permit out on the initial application, even though it transferred. Is that correct?
Mr. Chairman, I will let the Gaming Commission talk about their interpretation of the statute and how they've actually done it in practice. But, it's my understanding that an entity is issued the permit, and, if the membership of that entity changes, that doesn't change the term of the permit.
Thank you.
Membership or ownership or.
Director, would you like to address that?
Thank you, Madam Chair. Senator Cope, that's correct. So if there's a change of ownership anywhere in the permitting, that permit just runs its course through. It doesn't reset.
Please proceed.
On page 12, lines 5 through 11, creating two new definitions. And this was so we didn't have to write the words city, town, or county in every place that we were talking about them earlier throughout this new section. Creating the new definition of local approving authority. That means the local authority with responsibility to approve or deny the application or renewal for a simulcasting permit that's issued by the commission. So again, it's a city if it's within the city under this bill draft, county if it's within the county, unincorporated areas in this bill draft. But if you change that to have it be some other split of approval, you generally don't need to change any of your definitions because you already have this here. And you already have local approving authority used throughout the bill. Then local authority is just clarifying that it's the governing body of a city, town, or county in Wyoming. Continuing on page 12, another change is made here to 1125-104. And this sort of just came up as a cleanup amendment when the Appropriations Committee, or perhaps it's a policy change amendment, cleanup policy change that was desired as they were looking at these statutes that were in front of them. And this was that existing law requires 3 stewards at each parimutuel event. And then the commission shall also require at least 1 steward to supervise each simulcast location that is approved by the commission. Well, if every time you push the button on a historic horse racing machine is a parimutuel event, then having 3 stewards for every time you push that button can be wouldn't be very feasible. And so this live was added to clarify that 3 stewards are needed for a live parimutuel permit, and to repeal the requirement that 1 steward that they have at least 1 steward supervising each simulcast location. And I think that was ambiguity of not knowing whether, did that mean they needed to be on site? Do you need 1 person, 1 steward in every single establishment? Or does this just mean generally we can assign 1 person to manage all of them? I think just wanting to clarify that was the choice of the legislators who worked this bill, was to strike that language on lines 20 through 23, page 12. Then on page 13, 1125-201, subsection A, this is the existing statute that grants the commission authority to issue parimutuel permits and specifies that they can only issue those permits that has been approved by the Board of County Commissioners. So now that we are changing the law in the first section of this bill to say it might also be a city or town, we say except as provided for simulcasting permits. So making an exception there to clarify that there's not county commissioner's approval required unless it's within the county. You have to go back to 210. So just conforming that statute should try to work with the new stuff you're bringing in this bill draft. That highlighted language on the bottom of page 13 is what concerned me about the transfer language earlier in the bill, and that existing law that very wordily says that no permit shall ever be transferred or shall ever be granted except the entity that's getting the permit agrees that they're not going to transfer it or assign it or sell it. But again, I think that this works if the person is, if the permit is in the name of Joe Smith. It doesn't work as well if the permit is in the name of a legal entity and the legal entity has its own changes of events. So
We have a question. Co-Chair Cole?
Thank you. Yeah, just back up on that a second there, Tamara. And change of ownership, or let's say it's a corporation and there's different principles that change. Wouldn't there be some cases where we'd want to know about that and be able to reevaluate? And this may be more of a Nick question more than anything, but is there value in reevaluating or is it not? Or we need clarity and clean the language up? I guess that's my question. Whoever could answer that.
Madam Chair, Senator Kolb, yeah, there is a lot of need to know in that instance. The way that this has been interpreted by the commission was that this was designed that I can't come and get a permit under my name and then behind the table sublease out my operations to somebody else to run, because that person may not be able to legally obtain a gaming permit because of their history. So, but when we look at transfers of licenses or entity, like the purchase of an entity, the new people coming in or new officers, or they go under the same background investigations that the original applicants have to, and due diligence for all of them prior to that license ever being, that transfer ever being granted by the commission.
Okay, just follow-up question.
Follow-up?
Yeah, just so you're okay with this language there, Director? I mean, do you think this works the way it's written? I mean, I definitely need to hear your,
Madam
Yeah.
Chair, Senator Kolb, I don't see any problems with it.
thank you.
I have a question, if I could. In Article 1, Section 30 of our Wyoming Constitution, it says that there shall not be monopolies. And so I'm curious to know, with the transfer of permitting, is there language that we can put in statute to help prevent monopolies from forming as companies are being bought out under parimutuel wagering?
Madam Chair, I think I would need to look at what kind of a bill draft we would have to accomplish that goal, or what we could come up with to accomplish that goal. And I think, whether you're just talking about monopolies for the historic horse racing and the live racing industry, or whether you're talking about more broadly would be, some sort of a new antitrust regime in Wyoming, which I don't think we have too detailed laws on, but whether you wanted to just apply to horse racing and historic horse racing, I'm sure we could get at some goals of achieving that, some different policy options, but it is just somewhat inherently limited because you only have so many tracks in the state. And theoretically, I suppose you could have an unlimited number of tracks, but the facilities that are already there that can be built is just, there's probably a market cap on the amount of actual tracks that you'll be able to get. So Section 3 is the repeal language, and I copied it for you below. These are the existing statutes that need to be cleaned up if you do recreate the law in this way. This is within the definitions of simulcasting and within the definitions of the Parimutuel Act. That subparagraph A that we're repealing is that you can not conduct unless you have a permit. A permit would be issued from 3 years. And since that was redundant, where other statute already says permits can be issued up for 3 years, I did go ahead and take that language out. I didn't think we needed to say it twice on 3 years when I recreated it, but otherwise this is the same language you see in the beginning of this bill draft. The commissioner shall only issue a permit to an applicant that's authorized to conduct a parimutuel event other than simulcasting on page 15, subparagraph B is repealed because it's sort of superseded. Right now, this is the entire local approval, or almost the entirety of what exists for local control within Wyoming statutes for HHR right now is on page 15, lines 1 through 5, that says simulcasting may be conducted off the permitted premises only if the Board of County Commissioners of the county in which such simulcasting will be conducted grants its approval. So because that's superseded by bringing in other cities and towns and restating it and giving them all of the requirements and application procedures, that's just a straight repeal. Subparagraph C is the 100-mile rule. Right now, that's repealed from this bill draft. And subparagraph D is the authority to promulgate rules for simulcasting, and that's recreated there at the very beginning of this bill. Section 4 is the applicability section. It is redrafted from the prior bill, but extended out 1 year since we've moved a year in time. It says that existing permit holders, there would be no change for 1 year. And then after 1 year, permit holders would be subject to the act as it exists here, except that this one caveat on page 16, this last sentence, a city, town, or county may deny or withhold approval of a simulcasting facility permitted as of the effective date of this act only upon a showing of good cause as specified in this new section that we created. So if you recall, this bill might have the effect of having an existing permit holder that previously was granted approval by a county. They would now need to ask their municipality for approval, and the municipality has never granted approval. So perhaps they could deny it. Well, this provision clarifies that they have that same right as if they're renewing it. Only upon a showing of good cause can it be denied. That is this bill draft, and I'm happy to take any questions, or if you want to hear from the public, or if you want to work it, you can proceed in any way that you'd like.
Thank you. Committee, any questions for Ms. Tamra? I do have one for you on in the current language that we have, we give counties 100% and the municipality split of 50-50 tax. And I'm wondering if this legislation could also include that is split equally or 100% for the respective location. Would that apply to the same statute? I don't have my green books with me to be able to know which code that was.
Madam Chair, it's definitely within 1125. I can't remember if it's within the 100s, Article 100 or this Article 200, but either way, I think it's within the bill title to change that distribution. If that's something you'd like to do, it's within the same subject.
Representative Webb.
Thank you, Madam Chairman. I have the same question and concern with that, wanting that to be addressed, to see if there's a more equitable distribution between the counties and the municipalities. So I would like some information on that.
Co-Chair Cole.
Yeah, thank you, Madam Chairman. Yeah, my concern is this: if we put too many, ornaments on this Christmas tree, it's going to sink. And I think we should talk about the fiscal side of this separately, because it's a subject unto itself, much more detailed than just what we just talked about. So I would like to keep this bill as clean as possible to focus in specifically on obtaining local control and the ability to deny a permit in a bill. I think that's our best bet for when this bill gets sponsored by, hopefully, management council, whomever it may be, that it'll be successful. I think we got to be very careful not to do too many things with one bill, because what I found out is too many things mean there's going to be somebody who's just going to die on that hill over this. And we start losing support, and guess what? We've got nothing. In search of perfection, we fail. And so that's the reason why I have this opinion. I don't want to make it too cumbersome. I think we could get another bill draft cooked up. We could figure out one to get somebody to sponsor. But remember, we're working in parallel with other CapFin and other committees. Well, we're not a committee, but we're a task force. So we're working in parallel with them. I think what you said is valuable and it definitely needs to be addressed because I agree with you. But I don't want to put it on this bill. I mean, I just think it's gonna cause us more grief than help us try to get it passed. I just think it's too much. I mean, this is the task force, not me. So I think we all have to kind of get educated on this and, maybe with a lot of experience, it'll be clearer why I got, my experience has said, don't do it. But we certainly can get another bill draft going. I mean, I am not in opposition to that we can, come up with some sort of proposed legislation to be sponsored. I think if we do that, though, we probably should focus in on these fiscal issues that we're talking about. It's much broader than just what we just said, but it is definitely deserving of the time. But I want to try to get this bill move forward, in a state that can be sponsored by another committee. That was my goal. Now, what else we do, Representative Webb, that's great, but I don't want to burn our time and then fail. Okay, that's what my concern is. So that's why I say, let's get another bill draft going and we can do that and have LSO work on it. And then we can all contribute to that document instead of trying to make this an omnibus bill, which I just think has more peril to it than benefit. That's my 2 cents on it.
Representative Webb.
And I agree. My whole intent in bringing that up is I just don't want this topic lost.
Oh.
And that's whether it's in a separate bill or whatever, that's fine with me. It needs to be addressed.
Agreed.
I request during public comment that if WHAM has anything to say about that or the WCCA, that we have an opportunity to hear from them as well. Any further questions for LSO? Seeing none, we'll move on to public comment on 26 LSO Working Draft 145. You want me to come forward? Co-Chair Kolb is requesting WHAM and WCCA if we could have your comments.
Good afternoon, Madam Chairman, committee. My name is Matt Hall. I'm the Legislative Director for Wyoming Association of Municipalities. And with me is...
Good afternoon, Madam Chairman and Co-Chair Kolb. I'm Matt Murdock, Mayor of Pinedale, and also the newly elected President of the Wyoming Association of Municipalities. So exciting days. Thank you for this opportunity. I have some written comments and then I can answer any questions. We appreciate that you've listened to our concerns, this legislation. It is, we want to be very business friendly partners to the different businesses in this area. As you know, 44 of the 47 simulcast permittees sit inside municipal borders. So our cities and towns are on the front line of public safety, zoning, and community character. Therefore, local governments must have a decisive role in approval, renewal, and when warranted, revocation of every permit. We want to continue to support replacing dual consent with a single approving body, so long as any adjacent city or county that shares services receives formal notice and an opportunity to submit written comments. Local input should apply at every stage, from initial approval, periodic renewal, to potential revocation, in order to keep the process accountable from start to finish. I would prefer that the appeals continue in district court. Forcing small towns to conduct APA-style uncontested case hearings could impose an unfounded quasi-judicial burden. My own counsel has said he would rather not go that direction, but it is. If the committee finds no workable alternative, we can operate under that framework, just to be clear. Section 10 treats a relocation as an automatic renewal. Yet Wyoming State Statute 11-25-201A forbids a permittee from granting or turning over the operation or management of pari-mutuel wagering. I would ask that it remain clear that any transfer stay under the same permittee and governing body. Cities and towns differ in their attitudes towards gambling. Zoning alone can't manage late night hours, security demands, or social service impacts. Allowing local conditions such as hours of operation or location limits lets each community decide whether HHR truly fits its values and priorities. So in general, we're pleased with a lot of the changes that have been made. Thank you. And if you have any questions, happy to stand for them.
Committee, any questions? Mine would be, speaking of the distribution of tax monies and giving you local authority to be able to permit within your own counties, cities and towns. Putting it into a separate bill draft gives us time constraints to get it through the legislature. Do you have a thought on which way you would prefer that to go?
Madam Chair, do you want to go for it, or I mean, my initial, Matt Hall also speak, but Madam Chair, I think Senator Cope does bring up a very legitimate question. The pursuit of perfection does tend to cause certain bills to falter when we would have been happy with a lot of it. That said, a separate bill could get waylaid and distracted, and considering that the distribution is a concern, I mean, always on the local level, we would love to see that change, but we want to be realistic about it as well, and would hate to see this bill fail and falter for the lack of that issue. And I don't know if Matt Hall would like to.
Madam Chairman, I would agree. I think that what's important about this bill is it does give us that local authority, which previously we don't have.
Thank you for your input. We appreciate it. Mr. Riemann? Oh, go ahead. No.
Good afternoon, Madam Chairwoman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. Appreciate you taking up this particular topic. When I began working on this issue, in particular with the Appropriations Committee a couple of years ago, really had four priorities as we moved forward around this gaming issue. The first was clarifying local governance and providing where necessary that local governments could revoke permits. And that should be for a good cause. And I'm glad that that language is included in here. The second issue was that there be an opportunity for public input and comment. And this particular legislation also has that component. We've also been interested in the 100-mile rule, again, which this bill addresses. I'll come back to each of these, but those were three of the four issues. The fourth one being problematic gaming, which I talked to you at the last meeting about. I know you'll take that up again tomorrow. I don't think it's an issue that you want to wrap into this particular piece of legislation. So in total, you're working on each of the components that we're interested in. I do think it's important that we have a statutory framework in place. You know, a couple of years ago, the Gaming Commission, the former Gaming Commission director came to me and said, "Hey, we could deal with this in agency rules and regulations." And I said, "Well, that's all good and well, but my folks are local elected officials. They shouldn't have to come to a body such as the Gaming Commission to address these sorts of issues. They should be able to do that on their local turf and to address what their own constituents want." So I do think it's important that we advance legislation. To each of the issues in the bill, the 100-mile rule, it's certainly something that I've had members in each one of the camps on that particular issue. Currently, we're an advocate for removing the 100-mile rule from statute, which this provides. At a minimum, we would request that it go to the county border so that the decisions in one county aren't imposing decisions in another county. So would at least put that to you. Two, there's one issue that I'll bring up in the bill. And first off, Tamara did a great job of restructuring this. It was a bit clunky in terms of existing permittees versus a renewal. And the way she's combined it is absolutely appropriate. I don't know if this is an issue, but on page 9, and it's text. I just think this is where it would go. It's not text that's in here, but this is the area where it carries over from page 8, where we're talking about the right to revoke approval or to deny a renewal. I don't disagree with any of the pieces that are put there, and maybe this is already there, but I'm concerned in an instance where we have a renewal application and something has come up through the process and, over the course of the previous 3 years, and the local government is working in good faith to negotiate towards a new agreement and to place something new into that agreement, whether this language actually allows us to do that, or to deny based on the fact that we can't put something that is a reasonable condition in. So I had proposed at a previous juncture that we add a provision that would say something to the effect of, and I can get this to you in an email, but failure of the local approving authority who has negotiated in good faith with the permittee to approve conditions under this under subsection 3 of this section. I trust your staff to be much more articulate in putting that in there. But it's just, again, if we're negotiating in good faith and can't come to an agreement, then that might be a reason for us to be able to deny during that renewal process. To the biggest issue that I have, well, let me back up. No, I will go to the biggest issue that exists here. This bill bifurcates. Right now, of course, the county is the entity that provides the approval. That's been in place for 4 decades or more. And to be very clear, and I've been absolutely transparent about this throughout any of the hearings that I've testified at, we have no issue with the municipalities having a role in this process. It should absolutely be something that's defined. But I think my members oppose removing their role when it's inside of the municipal borders. You might ask why, and that's a fair question. And I would say this is perhaps part of the answer that I would give you relative to the revenue issue that you just brought up. First off, it's not a municipal vote. It's a countywide vote. So in other words, if you don't have a county opportunity to participate in that municipal process, you sort of excluded the others that were part of that decision-making process to allow for the activity to happen. That's not the most important one. I'll bring up some other issues. We have, at least to my understanding, 3 counties where the entirety of law enforcement, of course, through agreement with the municipalities, is provided by the county. If you go to Sublette County, it's entirely the sheriff's office that responds to those issues, regardless if it's in a municipality. And that exists elsewhere in our state. Prosecution, that's a county responsibility. Mental health, substance abuse, problematic gaming, those are all responsibilities of the county. So regardless of the fact that the activity is happening in a municipality, the county bears some responsibility, some cost in that. And that's why I would suggest that any attempt to change the distribution formula will be mightily opposed by our members. I don't come here to say that we oppose this legislation, but I don't think we can support it in its current form, and would love to work with you and continue to work with WHAM. And I think that's probably the most important point that I would make, is that we're not in a disagreement with WHAM over that shared responsibility as it relates to our participation in those decisions that would happen in the municipal level. House Bill 85 gave one approach at that. I actually presented, I think, 4 other options to the Appropriations Committee during their discussions on this particular draft. Some of those were veto authority for counties. Some of my members would love to have. We didn't land there. We didn't hold there. We didn't feel that was absolutely necessary, but we do believe we should have a role in this process. And with that, the last thing that I would just touch on is the notion that zoning is the mechanism by which we can address these issues. I appreciate the sentiment, and I would suggest that it has a role in dealing with this. It's a tool that exists for local governments, and I would certainly agree with former Senator Ellis that it should be applied uniformly, and our approach to issues should at best be applied uniformly. But just let me point a couple of things out. When we're talking about zoning, and in particular with the county has no authority over zoning inside the municipalities. You have clearly stated in statute that we have no authority there. So we don't have any ability there to address things. It doesn't address revocation. There are clear provisions in the county zoning statutes that grandfathering exists. So once you've approved something, and Co-Chairman Kolb's talked about this, it's forever sort of approved moving forward. And it doesn't allow us to address those non-zoning issues that might come up, those public welfare issues that can come up in these situations. So it's an imperfect tool. Is it one part of the equation? Sure. But it is not the full piece. And so we do need legislation like this, but this does need some work. And with that, Madam Chairwoman, I would stand for any questions.
Thank you for your remarks, Mr. Riemann. Any questions? Co-Chair Cole.
Thank you, Chairman. Well, Jeremiah, let's dive back into the part we left. You working with WHAM on some sort of an agreement between the counties and the cities on how you can work together for this process. Obviously, this is you're right. There is commingled, issues between counties and cities that are beyond the borders of the city. However, what have you come up? I mean, I saw that some of the legislation that made it to us that got stalled out was frankly kind of a bit too convoluted for me the way it was written. But have you worked with do you have anything you can propose or have worked on something that you feel that you and WHAM can agree upon on how to separate these authorities and yet make everybody, I guess, as happy as they're going to be?
Yep.
Just an open-ended question.
Sure. Yeah. Madam Chairwoman, Co-Chairman Kolb, what came out of House Bill 85 was part of that agreement. I agree, it's convoluted. It was a messy process, to be really honest, over the course of the last year to get to that language. And I wouldn't say that's messy for WHAM and WCCA. It was just the working group process, a whole lot of cooks in the kitchen. And I would commit we will continue to work, and I'd be happy to work with you and WHAM to come up with a more perfect process, or at least a good process for what that looks like. As I mentioned, I spent a lot of time and came up with 4 other options to try and to crack that code with that working committee. I committed to it, and I would commit that to you today.
Just a
Follow.
Yeah, thank you. Yeah, Jeremiah, I understand this. This is not an easy lift. And I do appreciate all the work you put on this, but we do have a little bit of time now. Not a lot of time, but we do have a little bit of time to maybe try to get it cleaned up a little bit, in my opinion, to make it more streamlined or smoother. But if you can, frankly, we have to have an agreement between you and WHAM on how you're going to do this, because, you've got your opinion and they have their opinion, and obviously we got to meet somewhere in between. So I think you're our best asset working with WHAM to come up with something that you guys can agree with. So when we go, if this thing makes it through, right, we have draft legislation presented to some committee, that we're not going to have a bunch of fighting here where you guys are going to go, well, but, you know, once again, I doubt if it's going to be perfect, but we got to find out what we can live with to improve the situation. And I think you well know that. So I'm probably preaching to the choir here, but look forward to moving something in. We don't have that much time to get something through, you know, to get something ready for somebody else to sponsor. But we need your help. Okay. I'll just say it that way. I certainly do.
You'll have it.
Thank you for your remarks. Mr. Reman, I ask, do you either have a digital copy or a paper copy that we can get as a committee of your 4 ideas?
Yeah, Madam Chairwoman, I had that in a Word document, I believe, and I'm happy to share that with you. Yeah.
Thank you. Any further questions for Mr. Reman? Senator McEwen?
Remember
Yeah.
that? Did I hear you say you would like to have veto power earlier?
Madam Chairwoman, Senator McCune, what I was suggesting is that some of my members actually came from that perspective, that we should have that veto authority for any activity that would happen inside of the municipalities. That's not what I'm articulating to you today. That's not what we agreed to when we got to House Bill 85 language. That language does not grant us any veto authority. If my memory, it allowed us to review and object to what was being proposed, the final decision-making power being that of the municipality. I will say that that language also gave them the ability within the extraterritorial jurisdiction area to do the same. So it wasn't just one-sided in our approach to that.
Follow up?
Thank you, Madam Chairman. I just got a kick out of that. The county commissioners and the municipalities vetoing legislation that we put together.
Mr. Chairman, Madam Chairwoman, Senator McCune, what I was suggesting is we would veto the municipal decision, not the legislative decision.
Oh, much better.
Thank you.
Thank you, Madam Chairman.
Any further questions for Mr. Reman? Co-Chair Cole?
Yeah, thank you, Chairwoman. Jeremiah, on the subject of these 4 choices, I would encourage one choice after you have a conversation. Because if you leave it up to the legislative body, God help you, of what those 1 out of 4 is going to be. So I think we're all better off to know where you're at. If at all possible, pick one, please. Because I don't object to the ability to comment. I think that's a good way of handling it. But we all know what that really means, right? The authority still rests. The ultimate authority still rests with the authority having jurisdiction, the city. But the county and the city are okay with that. It sounds like a compromise. But please come up with one thing you've come up with that you can live with.
Thank you, Co-Chair Cole. I still request the list of 4, but if you will share one with Co-Chair Cole, that would be wonderful.
Yeah.
Fair enough.
Rate them.
Any other further questions? Thank you. Hello.
Afternoon, select committee members. I'm Pete Lagore from Wyoming Horse Racing. And we wanted to provide some feedback on the local control bill if this is the appropriate time.
Yes, please proceed.
And also some additional comments on the 100-mile rule. And I know we've had some discussion offline about allowing Eugene to talk a little bit about the history of the 100-mile rule, as he was knee deep in the creation, living with it, and so on and so forth. So if you would indulge us for a couple minutes, it might be helpful in terms of the bigger picture.
Yes, please proceed. And welcome.
Thank you, Madam Chair, Senators, Representatives. Eugene Joyce with Wyoming Horse Racing, LLC. I started the company back in 2011, but prior to that, I was working for my father at Wyoming Downs back in the late 80s, early 90s. And the 100-mile rule was, it came into existence really, and my understanding of it is to really drive customers from OTBs to the live racing. The practice was that there was only one simulcast provider back in the day, and that was a company out of England, Ladbrokes. And so the tracks utilized the 100-mile rule at that point to try to get some support from the simulcast revenue, which was really minuscule. It was never meant to be monetized to support purses and live racing to a greater extent. That comes nowadays from each individual track running OTBs throughout the state. That's the practical matter. The 100-mile rule is antiquated. We have been de facto operating in this manner for over 20 years, and it has not inhibited any of the operators from starting a race meet, getting started as a company, and providing purses and race dates to the commission in order to be allowed to simulcast. So, as I say, there's a couple funny. The 100-mile rule comes from Representative Wallace, who just picked the number out of thin air. He got it out of another state. It was 50 miles, and he thought, well, Wyoming, it should be 100 miles. And I know the concern, and I was in the trenches with Senator Kolb. Thanks to his support and the Sweetwater Events Complex, we started live racing when there wasn't a long line behind me, but anybody that wanted to get live racing going back in Wyoming. But the reality is that the smaller tracks, the county tracks, did not fail because of lack of support and utilizing the 100-mile rule. What happened was Wyoming Downs was built at a time when Centennial Downs went out of business in Denver. And so there was all these horsemen from New Mexico and Arizona coming to Wyoming to run in a cooler summer atmosphere. And so the fairs, when they started, it was 100% quarter horses, and Wyoming Downs was 90% thoroughbreds. Okay. When Arapahoe Park was built in Denver, that siphoned off the thoroughbreds, and now Wyoming Downs was competing for the quarter horses that normally went to the fairs because they had overlapping dates and there was no problem. The Utah quarter horse people wanted to race closer to home, and that eventually led to the fairs dwindling down and moving on. But again, it was never meant to be monetized to in any significant way support live racing at another racetrack. And as I said before, all the tracks are all self-sufficient right now with the current business model that supports our entire industry. So with that, I'm happy to take any questions on the 100-mile rule.
Thank you for joining us today, Mr. Joyce. Any questions for him? I have one for you. Could you talk a little bit about the economic impacts that the HHR machines have had on the horse racing itself in Wyoming?
You bet. So as I said, there wasn't a long line behind me when I started the company. I started with 6 OTBs, and we had 4 race dates at Sweetwater County, and that's about all we could afford. A couple of years later, the HHR bill was passed, and that changed everything. I mean, I had a tiger by the tail. Didn't really know what to do. I reached out to a close friend of mine, Nick Hughes, who operated Kentucky Downs, and they had those HHR machines. When the legislature originally passed HHR, one of the models they looked at was Kentucky, and you would not think the state of Kentucky needed help to retain horses. They had world-class thoroughbreds. But the surrounding states around them had slots and casinos at racetracks, and it was siphoning off stallions and broodmares. And Kentucky racing needed something, and this provided a boost. And so when we went to the legislature to talk about that, we weren't reinventing the wheel. We were basically looking at Kentucky. And what we promised was that it will rejuvenate horse racing in Wyoming. It will absolutely energize the whole breeding industry, and it will result in more racing throughout the state. And I would tell you, we've delivered on that promise. You know, when you look at it, and some people say, well, how come we don't have a big increase in race dates? The calendar dictates when we can run in Wyoming. We run right now from mid-May to the end of September. And if you run any further past that, you run into weather issues. But what is happening and what you don't see is that as the horse population, as the purses grow, and again, ours are 1.9 million this year, and thanks to the vision of these two guys in creating the Gateway here in Evanston and Swan Ranch there, it's going to be $3 million next year. That brings in the horses, and that raises the amount of races you can run. More horses mean you can run more races. But where you do see an increase in horse racing over the last several years is the addition of Friday racing. And where you'll see it is not on the calendar, but you'll see it on the weekly schedules. As more horses come to Wyoming, you should see Thursday racing, Wednesday night racing eventually as the horse population increases. But it starts with the purse money. That's what the horses and the owners of the horses run for.
Thank you for that explanation. Any further questions? Seeing none, thank you.
Just to add some additional color before I get into local control commentary. You know, Eugene talked about the explosive growth of purses from 1.9 million to 3 million next year. That's really been driven by our ownership group's decision to invest in Wyoming. And since we purchased the company in December of 2021, we by the end of this year, we will have invested about $100 million in Wyoming. And, you know, our philosophy is we have a Wyoming first philosophy. We hire Wyoming residents, we buy Wyoming, and we participate in philanthropic efforts in the different communities that we operate. I know there was some comments about that earlier. We absolutely step up to the plate and get involved in our local communities. We are running right now, by the end of the year, we'll have about 350 full-time, part-time employees. When Eugene was involved in the company, when he started, that number was about 50. I'm just giving you this background in terms of what it's taken to drive the growth on the horse racing side. Is we had to prime the pump, so to speak, and generate the activity. And just to be clear, our Swan Ranch property and the Gateway property that we're constructing here is really designed to bring in out-of-state tourism dollars into the state, obviously tax dollars as well as money being funded to horse racing. And the Swan Ranch property has been very, very successful. Over 75% of the business is coming from Colorado. I think 15% is Nebraska, and a very, very small part of it is coming from Wyoming. So we're super excited about the opportunity here. You know, one of the things we've done as part of that process is we really liked the environment in Wyoming in terms of its stability and consistency and regulation and business environment. I know a lot of ideas have been floated today, and we would just respectfully ask that we be part of that discussion and to have a seat at the table. I mean, generally, we agree with managed growth. We think that's a good idea. We think the industry has gotten big enough that it's probably time to talk about those types of things. So we're really here to provide factual information about the business so you all can make a better informed decision. And I did want to comment, I think 2 years ago, or maybe 3 years ago, we, as a group of operators, engaged to have an independent economic impact study done on the industry, and not just HHR, live racing, and all of the people that support that, the farriers, the vets, and, you know, people that grow the hay, and on and on and on. All the employment that's created, and their study came back roughly about $150 million. And granted, that's outdated today, but I would suspect that number's probably closer to 300 million today. So this is not a small industry anymore. And be happy to provide the committee with a copy of that report if you haven't seen it. I don't know if you have or not. But you know, moving on from that, and again, I'll be very, very brief. Generally, we are very supportive of the local control bill. We've been acting and operating as though one was in place. We traditionally have gone to the local communities, the municipalities, and made sure that there was support and agreement with what we were doing, whether it was a small project or big project. Then obviously, once we secured that, we went to the next step, which was to go to the county and go through the resolution process. And then ultimately that translated into packages being submitted to the Gaming Commission. So we like this bill. We just had a couple of comments. It was more about the process, and we're probably thinking too much into this, but at least wanted to ask some questions, I guess. The first one had to do with page 7, the lines 20 to 23 talks about granting approval for the same term as granted by the commission of the simulcast permits. It feels like you're trying to get all of the permitting process on the same cycle. As an operator, thinking through what that means and having to go through the renewal process and all the communities we operate in and so on every 3 years, it may have the unintended consequence of creating sizable bottlenecks. And I'm just wondering if you could think about whether that's actually even necessary. If the county is still going to be able to issue their three-year permits, they'll also have the clawback provisions in terms of revocation. It may not be necessary to push all the resolutions on the same cycles to permit. And I think the benefit of that is this spreads the workload out, both with the Gaming Commission as well as the counties. Clearly, we have to have an active permit. So we've got a resolution for the county. So we have an obligation, if the renewal cycle falls inside of an approval window that the Gaming Commission grants us, we would have to make sure that we had an active resolution and go through the renewal process anyway. It's just more of an observation than anything. We're just trying to think ahead.
Co-Chair Cole has a comment for you or a question.
Yeah, just a kind of an observation. Thank you, Madam Chairman. We want to keep these things in sync because of the possibility of revocation.
Mhm.
You don't want to have things disconjointed. There's other reasons. You're right. I mean, there's pros and cons here for doing it this way. The reason is for streamlined processes. Yeah, it's going to involve timing issues, right? We'll have to figure that out, because I don't think anyone has the intent of causing you grief because of a timing issue. However, getting them in sync, I think, has a better upside than a downside, unless if you want to prepare something that, explains why it's a downside and why you think it's not going to work. I think you can submit that to the task force and we can review it. I'm open to learning new things all the time, but right now, I think that's the reason. If you can come up with other quantifiable reasons that make sense, I think that's great. It's good information. We'll have a better product if that's what we decide to do. Thank you, though.
Understood. And we are perfectly fine with whatever the committee decides. We're just trying to think through the practical application of, what we're reading. That's all.
Well, just
Follow up?
follow up, Madam Chair. Once again, I'll repeat it. We need industry's help. We need the help from you folks that know the ins and outs of this to say why you think something's good or bad. Because without that, we're going to get flawed. And once this goes down and gets into the pipeline, your voice is going to be a squeaky voice, right? It's going to be really hard to hear anybody hear you. So we want to get it early. And if it makes sense, I don't think there's a person who's not willing to hear something that makes sense. So don't act, your opinion does count for, your industry's position. And I don't want to diminish that information. So, but thank you, Madam Chair.
Madam Chair and Co-Chair Cole, I completely understand and appreciate that. And we want to be part of the process, as I said. The next comment was on page 8 and to page 9 on lines 22 and 23, and then the preceding page 1, where it talks about good cause, failure to demonstrate commencement of simulcasting within 2 years, and then the 1-year extension. Some of the projects that we've encountered in Wyoming are complex, and they have taken longer than 2 years to start renovations or building greenfield projects. I'm just wondering if I'll say the second 1-year option could be broadened to the extent to give the community some flexibility in that. Because I think if it says 1 year, that's it. They're really, that's all they would have the ability to do. It just feels like if we're working with the community on a project and they know we're trying our best, to give them a little bit flexibility to potentially extend beyond the 1 year if needed. Now, granted, thank goodness we haven't needed it, but again, I'm just trying to think ahead about what could happen on more complex projects.
Follow or Co-Chair Kolb.
Yeah, thank you, Madam Chairman. Yeah, that's why it says good cause. So it's a term of art you use in writing this type of language. That's kind of a get out of jail card. If they decide that, you know, you're working good faith, that's good cause. You know, that's not good cause to deny you said permit issuing. So that's what that's there for, is for what you're talking about. Good faith efforts. The Gaming Commission deals with that all the time. So just wanted to put some color on that for you.
Fair enough. I think that was our comments, unless Nick, you wanted to add anything?
Yes.
Can I cut you off? Before we jump to Mr. Hughes, might I ask you a question?
Sure. of course.
Specifically on that page 8 to page 9, where it says the failure to demonstrate commencement of the permit within 2 years. Have you run into any applications that you were permitted, but then 2 years wasn't long enough?
Yes.
Could you give us an example?
Yeah, our Swan Ranch project in Cheyenne, and you know, certainly through no fault of anyone's, we had a series of weather delays and you know, having to go through an extended zoning process that what was originally was unanticipated. And county and cities were all very cooperative, but we just had to go through that process, and we had to do it in a certain sequence of order. And it just took a lot longer than we thought. And as we got started with construction, we've learned Wyoming isn't kind with weather sometimes. And we had several months of delay of construction. We ended up going past the 2-year mark. Not the 3, thank goodness, but we definitely went past the 2.
Thank you for that. My next question would be, would verbiage such as an act of God be one potential solution to that permitting process?
Yeah, Madam Chair, yes, that would be wonderful. And again, I'm anticipating what could happen, so it's always hard in those situations.
Thank you for coming today. Any further questions for him from the committee? Mr. Hughes?
Madam Chair, Co-Chairman Kolb, senators and representatives. I don't know about a squeaky voice, but it's a bit of a strange accent. So I'd like to just touch on 2 issues, but first I should explain. Pete's my co-managing partner. There's 3 of us. I'm the president of Wyoming Horse Racing and Pacesetter Racing and Gaming, which is the parent company to WHR. Firstly, I wasn't going to talk about this, but I think it's a pertinent point. It was mentioned earlier about, I'll use the word casino, which we're not locally, and also about Swan. As Peter's told you, both of those are touristics. When we bought the company, we had 10 outlets from when we bought from Eugene, and Eugene is a continuing partner with us. We still have 10, and we have 2 or 3 smaller ones in the pipeline, but we haven't really drastically expanded. What we had was what was very successful in Kentucky. I was one of the owners and partners in Kentucky Downs, which was in Franklin, Kentucky, which was a very, very, very small town, but it was 35 miles from Nashville, Tennessee, right on the border. And we opened Kentucky Downs, and as Eugene can tell you, Kentucky, the actual signature industry isn't bourbon, it's horses. That's why a horse appears when you drive into Kentucky territory. However, there were 9 racetracks, of which 6 were due to close. 6, and that's in the state that has horse racing as its lifeblood. we took a Hail Mary. We owned Kentucky Downs for since 2007. And in 2011, we were literally having to walk away. Horse racing is not a profitable business. It's a great business, but it's not profitable. We did a Hail Mary. We went for this little strange product that came out of Arkansas, which was called an IRM, which only Arkansas had, and all they had was 180 terminals. And we did it as a Hail Mary. It went crazy. The rest is history. It spawned HHR rather than IRM. And every single track in Kentucky stayed open and has even expanded. So that model of being touristic based, not locally based, we have what we call legacy properties that are for basically really for the local population. But since since I should say Eugene's opened, and since we bought, the expansion in those legacies has really come from our other operators, which we have a great relationship with. We work very closely with both of them. But our touristics, just to be clear, when it talks about you're going to put 1,000 units in a town that has not that many more people, it's not, Evanston here is not geared towards that. We opened up Swan with 250 units, gone to 300 units in bite-sized chunks, and we're probably about to go to 400, possibly. It has 1,000, the ability to go to 1,000. Why? Because we also need to understand, because we're bringing people in Swan Ranch, Cheyenne, we're bringing people from Colorado. Now, if you're driving an hour to an hour and 40, or even more if it's Denver, you might want to stay the night. So how do we justify going from the 27 million that we put into Swan, just in Swan, to potentially another 60, 70 million with a hotel and a convention center? It wouldn't be with 300 units. Same here. This is licensed, permitted for 1,000, just over 1,000 units. We're not opening with 1,000 units. We're opening with 300. Why? Because if we believe Utah brings out-of-state gaming dollars that will create Wyoming state tax benefits, especially because of Utah, because it's a longer drive, we have to have the ability to build the hotel, to build whatever other amenities we need to, in order to attract those players from outside of Wyoming. So we have 1,000, and that allows us to say, well, we can afford it, because if we were capped at the 300, we couldn't afford to build a $35 million hotel and another $20 million convention center. So that was one thing that I just wanted to kind of clarify. The other is this 100-mile rule. I think Chairman Kolb and also Eugene mentioned, this was a rule that came about in order to get people to go to the races. With the advent of not having to go to the races, people don't go to the races. They do, but in diminishing numbers from what it was 20, 30 years ago. This 100-mile rule put in place to safeguard those racetracks and attendance at the race meets, it's antiquated. And that's agreed by all the current operators that actually operate live racing and actually operate OTBs. The three of us, we have worked together, and in order to make sense of the 100-mile rule, the three of us, the three operators, we issue reciprocal agreements between all three of us. And we say, you know what, you don't need to close. When you're in Rock Springs, if you have an OTB in Rock Springs, don't close. If you have an OTB, excuse me, in Evanston, don't close. And that protects state, city, and county taxation. And I'll give you a number. June, last month, and this can be verified from the Gaming Commission numbers. Just in June, the 3 operators that do operate, they generated $3 million, just slightly over $3 million in taxation, the 3 of us. That was $1 million to the state, $1 million to county, and $1 million to city, just in June, just. It also generated $800,000 to the Wyoming Breeders Association, meaning we have incentivized people to breed here in Wyoming. We own horses. We actually breed horses here. In Sweetwater, we're starting very, very soon. We will have over 1,000 entrants. 1,000 horses will be coming to Sweetwater. Think of the lodgings, think of the farriers, think of the feed. You know, that's major, and that's just us. And I'm sure that WD and 307 have similar numbers. The 100-mile rule is a hurdle to us, to 307, to WD. It's a hurdle. It's not functioning as it was meant to function all those years ago. So we have to work together to get around it. It doesn't hurt anybody. It doesn't diminish anything. But what would diminish if for 3 racing blocks of dates, if each 2 operators at the close, because of an enforced 100-mile rule, because only 1 stayed open that didn't want to enforce the 100-mile rule, that 3 million would be significantly diminished in the month that was to occur. And with that, I'll stand for any questions.
Thank you for your remarks today. Any questions for Mr. Hughes? I do have one for you. When you speak about the attendance of the live horse racing, I'm curious to know, 30 years ago, these were happening events in communities. Given today's technologies, do you anticipate that we could get it to similar statute again today?
I think Eugene would be better to answer, but I promise you we have investigated every way to be able to do that, including classic car events, including beer fest, including all sorts of ways to try and commingle at Sweetwater Complex to bring people in. But I've been involved in racetracks, not only in the US, but in other parts of the world. None of it is, they call it the sport of kings. Only a king can afford to be in it, basically. And so consequently, you know, like the people don't attend, but I'm stealing Eugene's thunder once in a while.
Sorry. Madam Chair. I'm the only person I know that has operated every single racetrack here in Wyoming: Casper, Gillette, Rock Springs, and Wyoming Downs. Wyoming Downs, again, because of its location to the Salt Lake City market, benefits from people, or benefits from a situation in the Intermountain West. People on the weekends get out of town. They go to the mountains, they go to the lakes, what have you. Because there's millions of people down there, X amount of people want to come up to the horse racing. In a market like Sweetwater Downs, or Sweetwater County, I should say, it's the same thing, but we're only drawing from 40,000 people. So our crowds are going to be smaller. Now, they're small, but they're enthusiastic. You know, I've got literally this is our 15th year. There is a group of 12 people from Sweetwater. They have been there every single day. Now, this is why I'm an advocate of cloning, because I'd love to clone them all and grow those numbers. But we have a lot of positive things happen. We have a growing Hispanic market that loves the quarter horse races that are coming to it. So in the smaller markets, we've got to really hustle for the on-track stuff. That said, we do send our signal out of state. That kind of grows the betting pools to benefit the people that are attending the live races. But it's something we work hard at, but it's tough to compete with Wyoming Downs. I mean, they average like 2,000 people a day. And again, because it is a gateway, people in Salt Lake know if it's 95 in Salt Lake, it's got to be at least 10 degrees cooler up at altitude. And so you get a real strong pull there. But it's a challenge. I'm a horse racing guys. These guys I'm dragging them into it. They want to know where the profit is on the horses I've got them to buy and race. But there's a lot of challenges for all of it. But again, it's an agribusiness, and all of these success stories would not be possible if it wasn't for HHR. And so that's what you have to, focus on, I guess. I know that sometimes the numbers seem overwhelming to wrap your head around, but there's things that are happening. Like, for instance, here in Evanston, the local vet just invested $3 million in an equine facility because there are so many horses coming into Uintah County to breed, to race, what have you. Now, that's someone, you talk about somebody, gambling. I mean, he's putting his money on the table, looking at the future of horse racing here in Wyoming and saying, hey, I want a shot at that. So with that, I'll have you take any remarks.
Any further questions? Co-Chair Kolb.
Yeah, thank you, Chairman. I don't know if it's the right time to ask the question, but I think it's probably going to have to ask this and hear your opinion. We do some limitation on the amount of HHR machines to race days. I don't know if you folks have put any thought into this or you heard the conversation, but that train's coming. And what is your opinion about race day per X amount of machines? I realize I probably caught you flat-footed on this, but just where are you at with that concept of, how viable is it for you? How not viable is it for you? Does it, what do you need to keep the present number of, say, machines? I mean, how do you comply with the race days?
Right.
And make it work? I mean, what does that look like for you? And if you haven't have an answer, I understand, but just your thoughts right now.
Mike, Madam Chair, Senator Kolb, my comment would be when I first came back here in 2011, the law in the books was 16 race days to get your permits. Okay. My good cause was there hasn't been a race here in 2 years. I think I can put up my money, race for 4 days, try to get the OTBs up and going, try to generate some revenue. But at that meeting, it was in June of 2011, I told the Parimutuel Commission at the time, I said, I'd like to get the conversation away from race days and talk about purse money and racing opportunities. Because the reality is, because of the calendar, if you're a horse owner, you're lucky to get your horse out maybe 6 or 7 times. So that every time you run, you want to run for the highest amount possible. Okay. And so if you have too many race days and too few machines, that's going to suppress the number, the purse money for an individual race. And right now, our average purses are starting to hit $12,000, $13,000, which means the winner of that race is getting $6,000 or $7,000. Your training fees are probably anywhere between $1,000 and $1,500 a month. So every 4 weeks, or excuse me, every summer, you'd need to try to win a race in order to help pay for your costs. So again, depends on the formula, Senator Kolb, I guess to say, but I don't believe it's race days. I believe it's purse money and racing opportunities. That's why I don't like an overlap. I like that even if we had to, get a 4th operator in here, it would actually compress the race days, down to 4 races a week. Maybe people come down to 16 because you have to accommodate. Right now, we got 20 weeks of racing. So how do you accommodate 4 for operators. And the reason I don't want to overlap is because now I've got to decide where I race that horse. If the purses are kind of even across the board, that gives me a nice circuit to run out through the summer. So that would be my 2 cents.
Follow up?
Yeah, thank you, Madam Chair. So the reality is, gentlemen, how are we going to deal with local control and the amount of machines and that whole subject? This was one way of trying to do that, okay, to increase the purses. So I guess I encourage you to put your thinking caps on, start thinking about other mechanisms that would work, because somehow this has to be gotten brought in control. Okay. That's the reality.
Yeah.
And it's going to be better to do it with help, you know, on the industry, because I certainly don't want to make a mistake and damage the industry. I want to grow the horse racing industry. Frankly, that's my personal opinion. I want the horse racing industry to grow. And we got to get there somehow. So I realize there's no perfect solution here. Okay. I get that, but there's never going to be a perfect solution. There's going to be a compromise that works. Works for you, works for us, works for the people that we represent. And that's really, I think, what's important here. So I think the devil's in the details, and that we're talking about them now because, well, sooner or later we have to talk about it. Also, there's going to be some sort of other mechanism, population based, which is going to be another issue altogether, right? It's going to have consequences and impacts. So if there's some way we can do it that's simpler, that boosts the industry up, I think that's worth a conversation for this task force to listen to, and to go, okay, these are our choices. But believe you me, it's either going to come the easy way or the hard way, right? There's no escaping this. I mean, the sentiment has changed in the state. The industry's exploded, which is good, right? It's great for the horse people and great for racing, but we're going to have to do something, right? And you know, the lay of the land is going to be probably a little bit different at the end of the day. I think the worst outcome you could have is have a bunch of legislators start out thinking things for you, because, you know, probably the best solution won't come from that. It's going to come from a cooperation between the industry and the people that we represent, you know, and those folks saying, well, good heck, there's, you know, gazillion machines out there, and it seems like a lot. So, you know, you got to battle that too. At least I guess look, that's probably our side of the equation, but what are we going to do? I mean, this isn't just going to just roll on forever and double and double and double and double, you know? So then how are we going to deal with it? You know, how are we going to allow our local communities to have control? I mean, that's really the crux to the question here, is how do they have any say so in this? You know, and at the end of the day, how can we be fair? And at least that's the way I'm looking at it. And I'm of course just speaking as a co-chair of this task force, but that's what once again, let's try to do something here, because putting it off isn't going to get us anywhere, I guess is my point. Avoiding the subject is going to lead to a terrible ending, you know, a less desirable ending is my, you know, 2 cents on this. So I guess what's your opinion? Where are we at? What do you think as the people that are really on the ground right now dealing with this?
Madam Co-Chair, Senator Kolb, I think, thank you for asking, one, for input. That's really important. And two, obviously, we were not prepared to discuss this, but I think we can definitely go back to the other 2 operators, have a constructive discussion, and potentially present some options that may make sense for everyone, and try to work this out. And as we said earlier, I think we're supportive of some type of controlled growth mechanism in place that keeps us inside the guardrails that need to be adhered to. It's fair, and I appreciate the transparency in the comment.
Chairman Colbert, sorry, I don't want to take up too much more of your time, but I would only add to what has been said here today. Let's talk about the elephant in the room, even if it's only a little bit of a conversation. Saturation. Okay. The public perceive that wherever they go, they're seeing, and I'll use somebody else's terminology, slot machines, which they're not, but that's the perception, right? Well, in many ways, it's because all those terminals are being lumped in together. That also means the skill games. I'm not here to denigrate skill games. But when you're only allowed 4 terminals in any one location, then it has to become a numbers game, right? You have to have 500 locations or 300 or, depending how many operators there are. So the perception is every time you go into a convenience store, every time you go into a bar, your favorite bar, every time you go into a gas station, suddenly you're confronted by 4 machines. So people believe, this is crazy. Everywhere I look is these terminals. HHR, and I'm not saying anyone's better than anybody else, but HHR has been very controlled. We are highly regulated by Nick and his team and the commission in general. We would support, as a company, we would support some form of legislation that manages the growth, because we need responsible gaming. I've been in this business of gaming, hotels, entertainment, and racetracks for 50 years. 50. This is my 50th anniversary. I was only 4 when I thought, no, I'm only joking. About 1. Anyway, but I've been in it 50 years. And we have opened in a lot of different places all over the world. Pete and I were corporate Hyatt Hotels. Pete was the president of Hyatt Gaming, and that was a massive, massive company. I was the international guy because I didn't speak American. I was the international guy and went all over the world. One of the things that we know more than anything else, there is absolutely no point in saturating the market. Each terminal costs us $23,000, one terminal. Okay, and then you've got all the ancillary expenses. But that one terminal, that one machine is $23,000. We're not going to put 50 terminals or 100 terminals or 20 terminals into a location costing that sort of money if we didn't think it was right. Eugene always says this is a supply and demand business. It's just that our version of supply is the touristic market. It's not to say we're not focused on the local market, we are. But our growth pattern is in the touristic market. So if you, for example, in Evanston or in Cheyenne said, well, we will limit the total number of terminals to population in those cities, why would we spend what could eventually be in Cheyenne or in Evanston, why would we spend 60 mil? Because we go for that outside market. So we would honestly support, and we work very closely with our 2 other operators, and we have not always common messaging, not always, because we're different. All of us are different, but we do understand that we can't talk as separate voices. Just as you're talking about now, where there has to be compromise, we 3 get together and have to compromise, even if we feel it should be this and they feel it should be that. And so we want to be part of this conversation. We will support what comes out, and we will. It's great, Chairman Kolb, that you said you're going to allow us to be part of it, because that's very, very important. And anyway, I've spoken enough. Thank you.
Thank you. I heard you say that you had an opportunity that you could potentially get the operators together and maybe hammer out some ideas. Do you think that you could do that within the next 30 days and get that back to us?
Madam Chair, yes. I mean, we've gotten together on other issues, as Nick has alluded to, and we've tried to work out solutions, whether they be legislative or other. So we do work together and understand the significance of this issue, and I think it behooves us to work together and provide some thoughts. So I can, and I'm sure Kyle Ridgway is watching, and Tracy from Wyoming Downs, and Frank Lamb's here. So I don't want to obviously speak for others, but we've worked together. We can sort this out and come back with some ideas.
Madam Chair.
Thank you. I look forward to seeing that within the next month. Representative Johnson.
Yeah, I would just like to encourage these 3 operators to talk to the 4th possible operator that is building a track in Laramie County. If you excluded them from your conversation, you would be cutting out 1/4 of the possibility of future horse racing in the state of Wyoming.
I'll answer quickly, we're not excluding anybody. It was said earlier that everyone wants an equal opportunity. We're absolutely about that. Build your track, open your businesses where you think it's right, and run OTBs. We when Eugene came into it, he was alone. Then it was Eugene and WD. Then it was Eugene, WD, and 307, and this will include Cowboy Gaming. Just as was said earlier, make everybody conform to the same regulations. No problem.
Thank you for being a collaborative partner in this. We appreciate your time today. Is there further public comment in the room?
Madam Co-Chairman, Kyle Ridgway from 207 has joined online. I don't know if he intends to testify though.
Thank you. Please proceed.
Yes, thank you, Madam Chair. I will keep it concise. I know that you guys need to move forward. There were two issues I wanted to address briefly. One of them is not necessarily part of this bill, although it is in certain part, and Mr. Raymond, on behalf of the Wyoming County Commissioners Association, touched on it. I would ask whether it's in this legislation or otherwise through other fiscal legislation to remember that municipalities do not exist in an island. In relation to the funds and provisions, the county specifically, I can speak for Uinta County. We did just face obviously our budgeting sessions and had substantial cuts that had to be made already. And in relation to that, it has been fun to educate the public as to what services the counties provide. And so I will just remind you that in each and every one of your 23 counties, your sheriff operates your county jail. Those are facilities that are utilized by each of your municipalities, and they are the only facilities in which you hold detention, whether they are for city charges, municipal charges, circuit court charges, or district court charges. Those are all in your county jails through your sheriffs. And Mr. Raymond already noted that many communities also rely on their sheriffs. We certainly have a very large Evanston Police Department, but even our Evanston PD and certainly our other local municipal police forces relies heavily on our sheriff's department as well for law enforcement. As to other services, I can speak specifically to prosecution. As you all know, you have assigned the duty of enforcing state statute upon the county prosecutors. You only have 2 districts in the state of Wyoming. I would estimate that and I'm focusing on Evanston, not to pick on them. The mayor is actually here. It is because it is by far our largest municipality. And I believe if it's not the only OTB or historic horse racing venue that we have, it is pretty close to being the only one. And at least 60% of our criminal prosecutions come from the city of Evanston. I would estimate 75 to 80% of all of our juvenile cases come from the city of Evanston. And 90% of all of our involuntary hospitalizations all come from the city of Evanston. And that is noted because those are all tasks that are assigned to my office, that if you were to cut funding more from the county, my office is one of them, and that is a non-funded position this year because our commissioners had to make some hard choices. And so I have had difficulty acquiring an attorney for my office of experience because we have a prosecutor shortage across the state of Wyoming. And so since I had that empty position, they chose not to fund it as a way to save money this year for our county budgets. More importantly, because it's not on the on the record, but that you guys did allude to it, I wanted to note that the News Media Corp at midnight on Tuesday, so effective Wednesday morning, closed 16 Wyoming newspapers, their entirety of all newspapers in the state of Wyoming, which will affect almost every small community in the state. That includes for Southwestern Wyoming, the Uinta County Herald, the Kimmer Gazette, the Pinedale Roundup, and the Bridger Valley Pioneer. And so that is every newspaper in Southwestern Wyoming outside of Sweetwater County. And so in relation to all of your legislation that you will be facing, and not just the ones that you currently have, but likely for every single title that you guys have for your laws have notice requirements. And quite frankly, so do the rules of civil procedure, which you guys don't have to deal with a lot, but certainly I do. And so in relation to that, then I would strongly suggest that we come into the year of 2025 and recognize that most people receive their news electronically. And in doing so, certainly there are some statewide electronic news services, but more pertinently, every one of your government agencies operates an official website. And so I would suggest, for example, in subparagraph F, and in contradiction to the man prior to me, I do have a very fast, natural pace of speaking, and I'm trying to do it for your time. So if I go too fast, tell me to slow down. But in paragraph F, where it notes that you shall promptly prepare and publish notice of an application in a newspaper of local circulation, I would suggest that it should read with comma, unless no local paper exists, and then in the local authorizing authorities official website, and then continue, so that it provides for an opportunity for notification. Here locally, for example, the closest local newspaper we are going to have now is from Co-Chairman Kolb's community. That is the closest newspaper to Evanston, Wyoming, in the state of Wyoming. I challenge you all to find an Oil City Miner in any of our local gas stations or other locations for purchase. You may find a Salt Lake Tribune or a Deseret News. And so those are concerns. I inquired to our clerk yesterday because we were talking about these issues. We are doing a special election, so it turned out that we luckily were able to publish at least the first notice for our special election in the very last printing of the Uintah County Herald that occurred on Tuesday. She is required to do that, but now every other notice is going to be problematic. She estimates Uintah County, from her duties with the commissioners alone, spent $24,000 last year in publishing in the Uintah County Herald, which was our recognized newspaper for Uintah County. If we go to a city of larger publication, whether that is in-state, which of course would be primarily the papers in Casper and Cheyenne, or if we did certainly Sweetwater County, the purpose of those public notices is to tell people locally that this is happening. And if they're not reading the paper, they're not going to get the notice. So in fashioning this legislation and any other legislation, I strongly encourage you to encourage the utilization of modern technology and find ways that we can adapt this, not just for this legislation, but for all of them, because the closing of those 16 newspapers is going to have catastrophic effects on our county budgets and on the city budgets as well, because you do have to publish all of our expenditures every month.
Thank you for your testimony. Senator McEwen.
Thank you, Madam Chairman. Couple questions. These newspapers are shutting down because they can't operate profitably, or because the big bad government's picking on them?
Co-Chairman Lean, Senator McEwen, I hesitate. Ironically, my undergraduate degree is in journalism, so I could say a lot of things about the career paths and other issues. However, those conglomerates, those used to be locally owned in each of those communities. And several years ago, a large corporation, if I recall correctly, is not even a U.S. corporation, purchased all of our small newspapers across the state of Wyoming. I don't know why the reason is that they're closing. I anticipate some of it has to be a financial choice because of the fact that we've gone from having a daily circulation, for example, in the Uintah County Herald, to bi-weekly circulation to a weekly circulation over the last 3 years or so. Representative Webb can certainly correct me if I'm wrong on that timeline, but it's certainly gone down. So I presume certainly everybody is very familiar with Cowboy State Daily and some other online publications. And so maybe that's the primary source of people's news source. I don't know. They're very easily accessible, but it wouldn't appear that aside from just logistics, I don't know why they closed it. I just know that it's a problem.
Follow up?
And I empathize with you. I live in Gillette. The News Record up there is struggling like you wouldn't believe. The building keeps getting smaller and smaller. And a lot of it's done online now and through Facebook. But I don't know what we do there. And my other question is, how much would you estimate your county budget to be? And what was the true cut on the property taxes, ma'am?
Co-Chairman Lean, Senator McEwen. First and foremost, I will say that some of this, unfortunately, for our traditional print media, I feel like we should have seen it coming. It's kind of like we've let the antelope hit the side of our car instead of seeing that the herd was across the street. Because I participated in an online media program through the University of Wyoming, and this is going to show my age, in 1995 and 1997 through 97 when I was still an undergraduate. And so these technologies have been along here for a long time. And so really we should have anticipated this occurring. This is something that really hit everybody. I haven't even had a chance to see, for example, how other states might have addressed this. We're not going to likely look to Colorado and Utah to find solutions. You're going to have to find other low population states because Denver is going to have their newspapers. Salt Lake has very large newspapers. We're going to have to look at other smaller communities in relation to that. I hesitate to actually discuss too much the county's budget just because I was not able due to my workload to be there for the entire budget session. My recollection was it was approximately $4 million that we had to cut. That was not only from the reduction in property taxes. There were also less carryover from the year before than we anticipated. And there was also less revenue from another source, which again, my apologies. I can't recall off the top of my head what that was. I am very close with some realtors. I think that the average real estate price and then therefore our property taxes has gone up about 19% over the last 4 years. So a 25% tax cut actually took us back to a budget that was pre-2020.
Follow up?
Actually, property taxes since 2020, the valuation on homes in the state of Wyoming went up 71%. Now, the inflation rate over those 4 years was about 19%. There's 50-some% left that where to go? In the last budget session, we added 1.2 billion onto the budget at the last minute. So I guess I get a little ornery when people want to blame this all on a property tax cut. And it's actually many sources of revenue. Your property tax cut here was tiny compared to your overall budget.
Representative, Co-Chairman Lean, Representative McEwen, I can only speak for Uintah County. I am not a part of the other 22 counties. I will say that Uintah County, certainly we have had increases in our property values. There's no getting around that. When actually fact checking, for example, we had a citizen that came to one of our commissioner meetings recently and said that he had had an 82% increase in his property value. When I actually looked at the property values and assessments, it was 18%. And so some of that is, I think, a perception versus reality. As far as our county, I've stressed that people need to remember that the county budgets only receive 11% of the property taxes. As far as at least our county, that is the percentage of the actual property tax that is received for budgetary purposes for our county. And then that has to be distributed over an entire generalization. If you match a job in the Uintah County compared to the city of Evanston or comparable sizes, all of our employees are paid less. And so we are not in Uintah County expending money that is beyond reason. And we, in my opinion, when I came into office, there were 5 attorneys in the Uintah County Attorney's Office. In 2015, you can imagine, I'm sure you recall, we were facing some fairly substantial budgetary concerns. We immediately cut that office down to 3. We have had, for example, a doubling of caseload that has occurred, which justified you all adding a judge to our county recently. But we are still operating off, well, we just finally hired a 3rd attorney. I had 2 attorneys in my office for 3 years. So in relation to matters, at least for UNT County, I will stand strong and affirm that UNT County does not spend money wastefully, and we are not exceeding our budgets in any fashion.
Thank you, Chairman of Revenue. I appreciate the revenue talk, being a member of your revenue committee, but I'd like to get back on gaming if we could.
I didn't mean to imply that you waste money. If you'd like, we can get together and I'll show you the exact effects of that property tax cut and how small it was. And I apologize, Madam Chairman.
You're doing wonderful. Thank you very much. Any further questions today for this guest speaker? Co-Chair Kolb?
I can't resist because Senator McHugh and I go round and round about this topic, so I'm in agreement with you. Sweetwater County's in the same boat. It's not a hamburger grinding machine, and nor is it on topic, but we're all facing challenges, and the money goes to other places or in the county budget. So just putting that out there. Appreciate your testimony. I would challenge you though to tell me how you get into the state mental hospital for an evaluation when you're in jail and you can't get an evaluation. I think there's a huge problem there, but once again, not on topic. But thank you for your comments.
And Chairman Kolb, thank you for those comments, and I would love to talk to you about solutions for 7-Eleven-303.
Thank you very much. Director?
Thank you, Madam Chairwoman. I'll be very brief on Bill 145. I just wanted to ensure that you all have a complete understanding of what the commission is doing in parts of this. On page 5, lines 2 through 5, it talks about identifying the specific location that is required in the application that they submit to the Gaming Commission that is vetted prior to approval. I send agents or inspectors into the field to inspect the property prior to even getting on an agenda. As I had spoken earlier, lines 7 through 23, we don't have it in formal rules, but the commission actively solicits public comment from the municipalities and counties and the areas for applications that we do receive. That's becoming a more robust process, and it's getting better. So I just wanted to point that out. On page 7, the reasonable hours, lines 5 through 9, that's also included along with their applications to the commission. They have to submit a plan of operations. That plan of operations goes over all of the operational guidelines of that facility. If they say that they're going to operate that facility from noon to 10, Monday through Friday, and then midnight on Saturday and Sunday, and they want to deviate from that, they have to notify our office and seek approval to deviate from those hours. Before any deviations of hours are granted, our staff always looks through municipal ordinances for the local municipality to ensure that it's coincides with their local liquor laws. We've actually had one instance since I've been here where we've actually denied an hour change request because they wanted to extend it past the 2 a.m. hour. And we wouldn't grant that. We wouldn't allow them to do it. We told them that they had to close at 2 o'clock when the bar closed. Also on page 7, items 11 through 14, the designation of areas, they are required to submit their floor plans. Their floor plans are reviewed and vetted. And then at the completion of the approval and build out, they have to do what we call a final walkthrough, to where we'll send agents or inspectors into the field, and they will actually have the approval documents that they were given with the floor plans that was approved, and they will make sure that the final build out of that location falls in line with the approved floor plans that were approved by the commission. And lastly, I just a quick comment. I just want to be on the record publicly of stating, if there's ever a county or a municipality that is finding any sorts of issues with an operator, please contact our office. Like, we want that information. I got a team of law enforcement officers, and I also have a team of inspectors that sole purpose is to investigate any of these things. I've not ever received a call from a county or a municipality with a complaint on a location, but if they're out there, never hesitate to call our office. If you all know of any, please send them my way as well. I would love to speak with them.
Thank you.
Yeah.
Any questions for the director? Co-chair Cole.
Yeah, thank you, Madam Chair. Just a quick comment. Nick is director, don't take it as anything more than us wanting to codify something, a statute, instead of hoping for the best with rulemaking, which is, I know you're doing a great job over there, but it's still subject to rulemaking, right? Instead of just being in statute, it kind of alleviates the guesswork. So that's kind of the reason why this has been memorialized, instead of going, well, I hope they're doing the right thing over there, right? So don't take it anything more than we're trying to make it more clear for you as a gaming commission on what the statutes are.
Madam Chair, Senator Kolb, I appreciate that. I just wanted to make sure that you all understood that we do have those processes, and they are required to submit that stuff. So when they come up here and tell you that they are highly regulated, it's not them just trying to make me look good. We hold them under pretty strict guidelines. Thank you.
Thank you, Director.
Madam
We're going to
Chair.
take a 15-minute break. We'll return. Representative Johnson.
I would just like to ask the director if these HHR facilities are governed solely under zoning regulations, and a county or a city had a beef with one of these organizations, they would bring it to you and you would immediately facilitate the right proper response to that. Is that correct?
Madam Chair, Representative Johnson, that is correct. If a municipality or a county brought areas of concern currently from one of our operators, whether it be, increased police calls, or they were seeing things that they were having problems with currently, our office would absolutely look into that and present those findings to the commission as a whole for their consideration. And whether it be that there's some sort of a action taken against their license by the commission, I mean, that would entirely be up to our Board of Commissioners, but it would definitely be looked into and investigated and presented to the board.
Thank you.
Follow up? Thank you, Representative. I apologize. I didn't see your hand. We are going to take a 15-minute break and we'll come back at 4:30. I just want to take a minute and stretch. We will continue public comment. We do want to hear from you. Thank you. One. Karen, are we live?
Yes, ma'am, we are.
With the return of our senators, we have gained our quorum. We'll get started. We're going to go to an online comment. Is Mr. Ridgway available?
Hi.
Welcome, Mr. Ridgway.
Can you guys hear me okay?
Yes.
Okay. Good afternoon, select committee members. Thank you, Madam Chairwoman. My name is Kyle Ridgway. I am the Wyoming president of Wyoming Downs and 307 Horse Racing. We are sorry, it's been a long day. What I wanted to talk about specifically was related to the local control bill and a couple of things. There were a couple points that were brought up by varying committee members that were asked of Wyoming Horse Racing and other folks this afternoon. So I know you guys are in Evanston today. I apologize that I couldn't be over there. I'm in Casper for family obligations. But I wanted to talk about what's going on at the track in Evanston. So first of all, Wyoming Downs owns that racetrack. It's a private racetrack. Wyoming Downs has invested $2.7 million in improving that real estate since June of 2024. That includes things like construction of stalls, installation of water suppression systems, a new rail, security cameras, and an entire AV and IT overhaul, landscaping, a new starting gate, $1.3 million of new equipment to maintain that track. I was over there for the Governor's Cup weekend. I've got the attendance figures for our race meet this year, 2025. We've had peaks of over 2,500 people in attendance on a given day. When I was there, when you walked the parking lot, by hand count, 90% of the plates are from Utah. It's literally Utah, 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 Utah across the board. We've had over 1,000 horses this year at that race meet for the full 6 weeks. Over $3 million of purse money will probably be awarded this year, not including added. It's a significant thing. And so, Madam Chairwoman, to go to one of your questions I think you had to Mr. Joyce about, can this ever get back to what it was? Evanston is proof that it can, especially with the folks coming over from Utah for the races. It's impressive. And there's significant investment to be made at that property. There are so many unique things that can be done. We are having double the betting handle at the track as we were in the year prior. And for context, I think the population sign on the city of Evanston says there's, 9,000 people or something in Evanston. If you think about 2,500 people coming over every weekend and staying for 2 days, you have 1,000 horses in town. You have all the folks associated with those horses, the grooms, the trainers, the owners, the family members. You're increasing the population in that area by, 20 to 30% on a back of the napkin. It's a significant thing, the Evanston track. And there is so much opportunity to continue to grow it because in other parts of the country, particularly in this region, there are tracks that are struggling, like Arapahoe Park and some of the other tracks that we pull from. So a lot of the horses that are coming specifically to Evanston and even to Gillette aren't from Wyoming. In Gillette, we spent probably $500,000 building a access road to new stalls because we had over 1,000 horses at that meet. I was laughing when Mr. Liguori previously testified about the economic impact study from 2023, because I had it in my notes as one of the things that we wanted to talk about, that, this industry had an economic impact of $150 million back then. And it's probably double now. As we talked about at the last select committee meeting, our organization combined employs over 400 people year round. And that doesn't include, the 100 or so folks that work at the track seasonally, and all the other people, contractors, that get benefit out of what we're doing. So I just think that is something that's worth pointing out, that happens with these machines. It becomes a symbiotic relationship where the revenue that's generated from the machines is going right back into the track. The investments being made, grandstands are being updated, consumers are getting a better experience, the advertising's better. The partners that we have at Wyoming Downs and 307 Horse Racing are significant horse racing operators. They own Kentucky Downs, the racetrack. They run race meets. They own thoroughbred race horses that have been in the Kentucky Derby and been in the Preakness. So it's been wonderful to be partners with people of that caliber who want to make an investment in Wyoming. And it's wonderful that folks of that caliber are partnered with somebody like me and people like my organization that are based in Wyoming, that are committed to see this industry grow Wyoming and for Wyoming to benefit from what's happening here and for as much of the money to stay here as possible. As far as the local control bill, I personally have had a long history with the development of that, going back to Converse County, when we had to have an election in that county to get our Douglas location, and when we negotiated a resolution that had a lot of the provisions that are in this bill. The one point that I would make about we've supported conceptually the local control bill the entire time. The one specific provision I would talk about is there was some communication and conversation earlier from the committee about the word transfer and transfers specifically. There should be two ways that transfers are treated in this bill, because there are two different transfers. The first is transfers of locations, meaning moving from one site to another. So for example, a transfer of location would be Wyoming Downs had a leased property in Sheridan that was an old Sherry's restaurant, and we purchased a different piece of property and invested $2 million in that new piece of property and moved our location and those machines from the old place to the new place. And there was a process we needed to follow for that, to say, we want to take this permit and these machines, but we want to go to a different place. We're doing the same thing with our border site, where we're taking a permit we had at Terry Bison Ranch and moving it to a different place. That should be treated like liquor license transfers, and the localities should absolutely have say in how those transfers are done. But when it comes to ownership transfers of the underlying permits, that's a function that the Gaming Commission already has jurisdiction over and should be involved in. Our experience was we had, when we went through this transaction at 307 Horse Racing to partner with Wyoming Downs, some of our county resolutions specifically said we couldn't transfer the permit from ourselves. And that was a custom piece of language that certain counties wanted. That's why we're in favor of this statute, is because right now we have 8 different resolutions with 8 different counties that have different obligations in them. So our preference would be to have a statute or a rule that clarifies how it works in every county, so we're not renegotiating. Regardless, when we had to convert our corporate form for tax purposes from a corporation to a limited liability company, we had to go back to every county to get their approval for that conversion and to amend the resolutions. And we also had to go to the Gaming Commission to have them vet the change of ownership in the permit, the change of percentages of who owned it, and all of those things. So the Gaming Commission is the entity that should be in the best position to vet the ownership of permits, background check, and those kinds of things. The cities and the counties should be able to rely on the Gaming Commission's work related to ownership transfers of permits. But the cities and counties should absolutely be the first stop in moving locations or moving machines around from one place to the other. And I don't think that that word transfer should get commingled. I'm not even saying that it is in this bill as currently drafted, but that would be our piece of feedback that is unique to the other testimony, because I don't want to go back through previous testimony. The other point that I would make about the industry in general is, since my involvement 5 years ago as the original funders of 307 Horse Racing and the original folks who helped grow that company and grow the Derby clubs, the product offered to the people in Wyoming has substantially improved. If you look at what the offerings were and what the locations were, the product has substantially improved in the environment that we're in. So I understand that there is a lot of conversation about how much of this should we have, how much growth should we have. That's true with every industry. That's true with oil and gas. That's true with these conversations around, wind and solar and uses of land. That's true with, gas stations and other kinds of things that have to get permits. If you look at, the LSO's memo, as Eugene Joyce talked about, this legislation was modeled on Kentucky, and Kentucky has very limited sideboards on the industry outside of, they have a strong regulatory body that understands saturation. We have this saturation study. We have a gaming commission that has a statutory framework to analyze every location, which includes, is the market saturated? Is this location a benefit to the state of Wyoming? And the other factors that were contained in the memo. And so there are a couple ways you can approach regulation philosophically. One is you can have artificial quotas and caps, which is cap and trade models or some of our liquor license modeling in Wyoming. Or you can have a more flexible framework that monitors and allows the industry to develop based on the facts on the ground. And you either trust the regulatory body to operate in that flexible environment, or the legislature creates caps and sideboards. And as somebody that's in the industry, we can operate in either of those environments. And we're happy to have conversations and interface with, which of those is more appropriate for Wyoming. And Wyoming has multiple models for that, depending on different industries that you look at. I think the point is, if you look at what's happening at the Evanston track, what's happened to this point in Wyoming has been very, very successful. And there is a ton of growth left at that track and in the competitive environment we're in now for the product to continue to get better for the Wyoming consumer, more responsible, cleaner, with better hospitality. And so, I understand that there's a lot of conversation. I'm happy to engage in conversation and answer questions and give opinions as needed. I don't want to waste everybody's time, but I just think this local control bill is a strong way to help create sideboards in a flexible way without quotas and caps, because essentially what's happening when you do that, the danger in that is you cage in what it can be, and you potentially, have unintended consequences when you do that, right? So it's a balance. Those are my comments, and I'm happy to answer any questions about the bill or other issues.
Thank you, Mr. Ridgway. Are there any questions from the committee for Mr. Ridgway? Seeing none, thank you for joining us today.
Thank you.
Next public comment.
Thank you, Madam Chair. Affie Ellis with Cowboy Racing. I'll let my co-presenters also introduce themselves.
My name is William Edwards with Cowboy Racing.
And Shane Schultz on behalf of Cowboy Racing.
Thank you, Madam Chair. At the outset, I want to thank Mr. Ridgway for laying out a great case of what we're all excited about with the Cowboy Racing's Thunder Plains project in Cheyenne. My friend here has testified before about the excitement, why he got into this industry. His family's in the development world. They know how to move dirt. They know how to build things. And so this idea of building a track, checks a lot of boxes for his interest as far as bringing economic development and supporting Wyoming's ag industry to light. And so I just want to thank ECL for all the investments they've made in Wyoming Downs. We'd love to be part of that conversation and hopefully elevating the horse racing experience in Wyoming. Before I start talking about House Bill 85, I did want to acknowledge at the prior hearing, I believe it was Wyoming Horse Racing who testified about the Swan Ranch project that they have. And one of the representatives from that company said, you know, I think it's a great thing when out-of-state companies come into Wyoming and want to invest here. And I want to just reiterate, we think that's a good thing too. I think our concern though has been, you know, what we're prioritizing. Are we prioritizing building gaming facilities, or are we prioritizing building horse tracks and growing our horse racing industry? And our, you know, biggest underlying concern though is just making sure we create a level playing field. So, you know, to the extent that our competitors are doing really great things, that's fantastic. Where we have concern is where we see opportunities that might prevent us from being successful in competing in that market as well. So in looking at House Bill 85 in this working draft, it does look a little different than what you saw during the session. At the outset, I'd say, you know, Senator Kolb astutely talks about Christmas trees, and in the legislature, how we like to start hanging ornaments on things. And all of a sudden it turns into this massive thing that you don't even recognize anymore. And the way, looking back at the legislative history of House Bill 85 was adopted and got to its final form when it hit the legislature, I think that's how we saw it too. The first bill the first version of House Bill 85 really just addressed that question of if gaming facilities in the county, it should be the county making that approval. And if it's in the city, it should be the municipality or the town. We have no problem with that. And in fact, we're happy to do that. You know, Cowboy Racing has appeared before Laramie County Commissioners. We're happy to appear before the Cheyenne City Council, laying out all the facts that we did related to our project. And so there's a piece of that bill that we absolutely support and have no problem with. Along those lines, there is some language in there about stewards. And I think you heard some testimony about how stewards have to be at every parimutuel event. That probably makes more sense for the live event, not for gaming facilities. But I think part of this is maybe breaking apart this bill a little bit. So we take these in chunks. You know, I think if you just had that steward bill, that'd be low-hanging fruit that I don't see the legislature objecting to. But if it's taken out, and I think that should happen for the industry. But there are other things in here that cause us a little bit more concern. And so as we saw the evolution of House Bill 85, toward the end of the process, we started seeing things that started raising our eyebrows and caused some concerns. Some of those have to do with due process. This bill is very much favors those operators that are in existence at this time. Specifically, the bill says if you're a new applicant, that you are not allowed to appeal an adverse decision from either the municipality or the county if you get it. And so we've talked about this before at length in the House TRW committee. And I've come to realize that there is some merit behind why that is in this bill. And I visited with Senator Crago, and I hope he doesn't mind that I visit about this. But, you know, what if a place like KC, Wyoming just doesn't want to have these gaming facilities at all? Shouldn't they be allowed to deny all new applications? And so if that language was inserted with that intention, I can appreciate that. But it does more than that. You know, we look at it in the context of what that means for us in Cheyenne. That means our competitors who have gaming facilities in Cheyenne have all of these protections and sideboards. And if local government gets it wrong, they can appeal to a district court. But as the new applicant, we don't have that same right. So I'm sympathetic to that concept, but I think that language needs some work. And I understand that Senator Crago has been kind of working on some solutions if he wanted to go that route. It might be worth visiting, though, however, Commissioner Covello, who's the chairman of the Wyoming Gaming Commission, he made the same remark before the Gaming Commission that the town of Torrington, they don't want these in their town within their town limits. And so they've, I think, made kind of a declaration to the operator saying, yeah, we don't want you in our town limits. And I'd be surprised if you see an application there. So I do think there are tools and mechanisms to respect that kind of local control. But this, in our view, this bill doesn't quite get us there. The transfer piece, you just heard from the prior presenter, and this is something I want to visit with you about. I've heard one of the co-chairs say, we need the ability to deny. We need the ability to deny. Okay. And I think that's based off a perception that the market somehow is oversaturated. Local communities don't want these in their communities anymore. But if you look at the charts that the Gaming Commission provided to you at the last hearing, and if you don't mind, I might ask Tamara if she wouldn't mind pulling those up. I think there's a solution here that gives us all a little bit more breathing room and time if we want to have some thoughtful discussion on this. I can appreciate the desire to have a bill for this session, but if you look at these charts, and you'll see the first one is Wyoming Downs. There are listed the location, the city, the county, the number of terminals, as well as the terminals on that site. There's a pretty big disconnect. For Wyoming Downs, they've been approved for 1,800 terminals, but they only have 1,200 in operation. If the Gaming Commission, which I think they have the authority to do, wrote a rule that said, we're not going to entertain any new gaming applications from you, Wyoming Downs, until you've built out that number, you would essentially halt a lot of applications from coming online until that number's built out. And that, you heard, would take some time. Wyoming Downs is building a casino here in Evanston. They're building one outside of Cheyenne. You heard that's a multi-year process, that they want to phase that in. So if you were to, the Gaming Commission were to do that, I called it maybe like a build out rule, that would really halt any new applications from coming across anyone's desks for a while. If you go down with Wyoming Horse Racing, same thing. You just heard Wyoming Horse Racing testify that they've got their Swan Ranch Casino or gaming facility up and running. There are about 300 machines. They're approved for about 1,000. That's I think a multi-year process for them to build that out before they can seek a new approval. And so I just wanted to highlight those. And I don't know when we'll start maybe looking at those charts a little differently. My understanding is that 307 Horse Racing and Wyoming Downs have merged to some degree. I don't know the exact nature of their joint venture, but it seems like they might be one operator doing business with two different names. So just something to think about when we're talking about slowing the growth down and doing it in a responsible way. As a reminder, you don't see it on that chart. Cowboy Racing has applied for 289 games. And so we would fall in that same category. Don't allow us to apply for new gaming terminals until we've built our facilities. I want to make a distinction though on that chart, because there are facilities that have build out plans, like the gaming facilities that were discussed. But in visiting with the Gaming Commission and living with those in my community, there is also a disconnect or a true up that maybe needs to happen. So you might have like a little shoebox gaming facility located on Del Range, for example. There's not a lot of expansion opportunities. And so that current facility, and I'm thinking actually Senators Steakhouse, I was looking at their numbers recently. I think they're approved for 120, but they only have around 80 on property. Where am I going with this? That's a great question. We're going to get back to it. There's a disconnect of about 40 machines. And so I think the question is, do we treat those 40 machines that have been approved as a transfer that they can just kind of move around and put and plop down wherever, either in Cheyenne or someplace else? Or should those be treated as new machines? I'd argue that if they wanted to take those 40 machines and quote unquote transfer them into a different location where maybe that affects different neighbors, different businesses, that those shouldn't be grandfathered in. That should be treated more like a new application. But back to the true up on that chart, there might be some facilities that are just confined to space. There's no room for growth. There's no plan by the operator to ever expand that facility. So I think that it would be a beneficial exercise for the Gaming Commission to visit with all the operators and say, hey, I know you're approved for 100 machines in this facility, but you've only got 80. Can we just change those numbers to say 80? And you might ask why those numbers are different. You've heard the fact that technology's changed. If you've gone to Las Vegas, you might remember those old slot machines. They look like little cash registers. Well, over the years, they get bigger and bigger and bigger and taller. So some of these places, it's a capacity question of how much physical space that place could hold. So I say that, Madam Chair, we have a lot of comments, and I could walk you through them page by page on House Bill 85, this version of it. But in essence, I just wanted to push back a little bit on the urgency of needing to get something done right now, this month, the next meeting, because I think if the Gaming Commission were to take kind of this build out prohibition on future growth, it would slow everything down. And then we would have time as a legislature, as stakeholders, to continue our work in coming up with the right solution. So those are some of our concerns. I think the last one I want to talk about are a couple more things. In reading the bill, that effective date is still a bit of a concern for us because Cowboy Racing, as I mentioned, has an application or plans to put games in 3 facilities. Because of a variety of delays, and Will can speak to all of this, their plans to run a live horse race in 2025 have been delayed. And so the notion, though, that we're not there yet. I appreciate that Cowboy Racing has made the commitment. They're not going to turn on a machine until they know for certain that they're going to run those 16 race days. So This bill has that urgency, I think, because people think, oh, we need to get it passed, but we're still concerned about the effective date because we're still going into that year, needing our approvals, needing to make sure we've got the track up and running. So I'd say, again, just one of our concerns about this notion that there is some kind of urgency. I think there are other things we could do that would slow this down dramatically. And then finally, the 100-mile rule. If you look at the evolution of how these bills, or how House Bill 85 evolved, at the start of last year's interim, at an April or May meeting of the Joint Appropriations Committee, all of the operators testified, we're very concerned about local control. We don't want to be subject to the whims of local control. And that's all prior testimony that has been spoken by the people sitting behind me, our competitors. But their tune changed and things started changing. You know, all of a sudden, now we like local control. Well, why? Our belief, and this is purely our belief, is because it was the insertion of the repeal of the 100-mile rule. And you've heard one prior person testify that it's antiquated. I don't think that quite does it justice to talk about it in that lens. When 307 first entered the market, and I don't want to belabor the point, that was a major, major issue for them. So much so that there was a bill introduced in the Wyoming House, and it was an ugly, ugly fight that never made it over to the Senate. So a lot of people remember that. And it really was the impetus of the big fight that happened in Campbell County. And so I just want to urge caution that just because 307 maybe has a different management ownership structure now, their concerns that they had when they were coming into the market are the same ones that we share. And I don't want to speak for Will, but I think that was an important part of the reason why they decided to move forward with their project. So we would disagree that the notion that the 100-mile rule is somehow antiquated. I appreciate that people in the industry who've worked on this for a lot of years maybe have taken a certain position on it, but there is a countering position. And I think I talked a little bit about it at our last hearing. Back in the 70s, there was a quasi-governmental entity in New York that wanted to broadcast the Kentucky Derby. So they went to the state of Kentucky and they went to the race organizers and they said, we want to broadcast the Kentucky Derby. And they said no. So this entity in New York did it anyway and profited and made a whole bunch of money. And the people in Kentucky were very upset. So Congress looked at it and they were sympathetic to what happened. And so they introduced the Interstate Horse Racing Act. The initial versions of that act provided a complete prohibition on that kind of simulcasting at all. But later evolutions of that bill said, well, actually, if Kentucky, and a big part of this is the horsemen's groups too, if you've got the state, the race organizer and the horsemen all comfortable with it, they maybe make some money off that simulcast, we'll allow that to happen. Although that technology has changed and now we're using machines, it's the same theory of how other people benefiting from gaming activity, simulcasting activity can still be used to support a racetrack. So, we can dive into that a little deeper. I've read some law review articles on that point, and I'm happy to provide those for those of you who like to read law review articles. But I just want to push back that is not our interpretation. It's not an antiquated rule by any stretch in our opinion. So I know I've gone on for a while. I'm happy to answer any questions or let Mr. Edwards do some cleanup on points I may have missed.
Mr. Edwards.
Good afternoon, Madam Chair, Co-Chair, Senators, Representatives of this Select Committee. Thank you for letting us speak this afternoon. Thanks to AFI for your historical rundown. I just wanted to touch on a couple points, just kind of fill in my layman's understanding of what I think AFI just went through. From a practical perspective, it's undisputed that purse money is incredibly important to the success of a racetrack. You heard prior testimony how important the purse money is, and I applaud the other operators in the state for increasing the purse money. And it's incredible what's happening in the state. Purse money is a goal and objective to a successful racetrack, and I think that's undisputed. What I'm hearing, though, is that in order for our new track to be successful, I have to go out and be incredibly successful in competing in the gaming market. Everybody's in charge of their own purse money, and that purse money comes from the OTB. And I'm left with the charge of going out and being competitive in an industry where we're talking about saturation, we're talking about proliferation, we're talking about limiting the amount of gaming, but we all want to support horse racing. And so what I'm hearing is you're on your own for your purse money. It needs to be great for the success of your track. But you know, you have to be, in order for you to be successful, you have to be successful in gaming. And that is gaming for the sake of, or opposite, that is horse racing for the sake of gaming rather than gaming for the sake of horse racing. We got into this to build the track to bring horse racing to Laramie County. It's an area that it's going to thrive in, and that's going to boost the whole industry for the whole state. And so our belief is that local OTB and that revenue creation should go to the local horse racing, at least go to support it. And that is what our application of the 100-mile rule looks like. And that's why we find it important, to the point that the reason it was first initiated is antiquated. I'm not going to concede that point, but assume that that's true. An example I like to think about, if you study history and you look at speed limits in this country in the late 70s, I don't know if it was the Nixon administration or not, but you look at the history of speed limits, they were originally enacted to soften the demand on oil. There was an oil supply issue, an oil embargo. That was the reason for speed limits. And then they enacted speed limits, the demand for oil loosened up, and lo and behold, the statistics showed that there was a substantial decrease in vehicle fatalities across the country. So while the initial reason for the laws of speed limits in this instance may be antiquated, the effects are now more important than the original reason why they were originally enacted. And I would liken that to what is going on with the 100-mile rule. We can talk about why it was enacted, whether that's antiquated or not. The fact of the matter is, it's a valuable tool to use local OTB revenue to support local horse racing. And that's how we would like to apply it. I'd also like to say that I don't think anybody's asking anybody to close. I do not want anybody to close. If how the statute is written, everybody entered into this market with the knowledge of the 100-mile rule, and how the statute is written is that if they close, that's their election. They don't have to support our purse money, but that's their election to close. That's their business decision. That's their business. Nobody's forcing them to close. And so I just want to make that part. The other thing that Affy touched on was the 100-mile rule is obviously contentious, and we can talk about it over and over again. I have an opinion. Everybody else seems to have a different opinion, but it's a contentious part to the point where we're all for the local control aspect of future legislation. I think we agree 90% on most of it. It would be a shame to have the debate over the 100-mile rule weigh that down and drown the local control aspect of future legislation. So I would humbly suggest to bifurcate the two issues into two separate bills. I don't think they're tied together. I think we can have two separate debates on both, and hopefully the local control legislation that needs to be enacted can fly through and be passed. If I may, I wanted to touch on another issue too about tying race days to the number of machines. I think that's a great idea. However, if you think it through, and I'm not saying anybody hasn't thought it through, but if you tie race days to the number of machines and operators allowed to have, we have a finite number of race days in Wyoming. And what's going to happen is it puts a lot of pressure on the Gaming Commission to equitably distribute the number of race days, because everybody's going to want more machines. So when you do that, the pressure is going to be on the Gaming Commission to make sure everybody's race days are equal, because everybody's going to be pushing for more days and for more machines. What the effect of that is going to happen is that everybody's going to have the same equal amount of number of days, and therefore the same number of machines. So if you really think about it, it makes more sense to tie number of games to tracks rather than number of race days. Otherwise, it's just going to be a mad grab for race days, and it's, might not be equitable. My last point, and I think this is my last point, the term saturation we've been throwing around, it kind of has this negative tone to it. And I don't think saturation is a bad word. Saturation, in my mind, is when you have two people competing over the same dollar. And we can use the example of coffee shops, for example. If we have more coffee shops than we have coffee drinkers, what inevitably is going to happen is that the coffee shops are going to have to compete for those coffee drinkers. And that means better coffee, that means better atmosphere, that means better service. That's when real competition happens. So the saturation point necessarily isn't a bad thing. I think Mr. Ridgway touched on this a little bit. There is a certain point when we have too much. I'm not gonna deny that. But there is a certain point that needs to go past the saturation point where true competition can make the market better and create conditions better through real competition competing for the same dollar. And so there. Local, I'm trying to read my own handwriting and apologize. So we're for local responsible growth. That is something that I think is a good term in the development world and that we use quite often. And I think growth unmitigated and gone wild causes a lot of unintended consequences and kind of frustrates the whole purpose you're doing it in the first place. But so we're definitely for responsible growth. I would just ask that that is where local control comes in and can be very effective. Each community, the more local you get, the more control they should have over the growth that they see in their local community. And so it's not a one size fits all for the state. And I think that is where local control can be very applicable. And with that, I will stand for questions. Thank you.
Thank you, Mr. Edwards. Mr. Schultz.
I don't really have much to add other than I appreciate Madam Chairwoman, Representative Johnson's comment earlier about the fourth entrant being Cowboy Racing, participating in the conversations, and we welcome that. And if there happens to be another entrant between now and you know, when this committee adjourns for its final time this year, we welcome them being part of it as well. And so we just want to be part of the conversation and want to work obviously with the other operators, but also the county Commissioners Association and WAM, and trying to figure out what we can agree on and what we can't agree on. But, you know, hopefully we can come up with some kind of solution that gets us, you know, 80-90% of it to the point where we need to be. Rarely do we ever get 100%.
Thank you for your brief comments. Committee, do you have any questions for the three testimonies that we just heard? Looks like you're off the hook. Thank you for joining us today. Thank you for your comments. Further public comment? Is there any further public comment online? In the room, public comment?
Madam Chair, Carl Allred in Evanston here. Just real quick, because I know you're looking at time, but as you guys know, I'd like to just see if this bill goes through, just strike the newspaper thing for now. I mean, it can't be done. So just don't cause any problem. Just strike it, the newspaper part. Also, the down at the bottom of page 5, that yellow part there with the permit holder may in advance of the designated meeting request a contested case hearing in accordance with Wyoming Administrative Procedure Act. That seems like putting the horse before the cart. I'm going to file for a contested thing. I don't even know what the hearing's going to be. You know, what issues are going to come up or in the meeting. So I think that should be stricken. I mean, you're putting something out there. I'm going to file for a contested hearing before I even know if it is contested. I mean, that doesn't sound very logical to me. So I think that it would be good to get rid of that. But very last thing, as Senator Ellis mentioned there, on page 10, line 14, saying they cannot have a right of appeal. I mean, you don't know why you get denied until you have that meeting. And if that denial is there for something that you have plenty of good justification to counter that, but you have no right to appeal. I think somehow they need to be able to appeal that. Now, to who? To the Gaming Commission, back to the original body. But, you know, maybe if they give you a list of why you were denied and just file an appeal back to the body. But for some reason, you should be able to have some point of bringing that issue back up, not just, well, sorry, you're done and you're out. Again, as I mentioned, that really stifles any competition maybe, and not saying that anybody would have nefarious reasons for denying an application, but you should at least have the opportunity to appeal that. That's only comments I had on this, but thank you.
Thank you, Mr. Allred. Committee, any questions for Mr. Allred? No. Thank you. Any further public comment? Seeing none, we'll close public comment on this section. We're going to go ahead and move the next LSO 26 LSO 152 to Friday morning. So those that are online or in the room to comment on the moratorium bill, please join us tomorrow if you are able to. We would still love to hear from you. If you're not able to, we will accept any written comments in lieu of your appearance. Any further? You want to move it? Mhm. We'll also carry over any committee directives on this legislation to tomorrow as well. 26 LSO 145. Aside from any committee directives on this legislation, is there any committee directives for the rest of today?
Not for today. I'd like to save my comment. I'd like to say, Madam Chair, I'd save my comments for tomorrow about further directives. I think we have enough to work on our plate. So I'd like to have the committee, you know, think about what what we just talked about and put it off this, what we just got off topic for suggestions for tomorrow on maybe what we'd like to see to clean it up. There are some questions, but I don't know if they're the, you know, difficult to answer questions, but there's certainly we have to go through it as a task force and come up with something that we all agree with as a good direction.
Thank you for that. Seeing none, we'll be adjourned for today or recessed for today until 8:30 tomorrow morning. Thank you.